From supplementary list for judgment item 1, the RPC 68 of 2015 rules.
The order of the commissioner has been set aside. The matter has been remanded to the commissioner, and you have to appear on 8/9/2025, all the parties. And then fresh order has to be passed within 6 months. The parties have to maintain status quo with respect to the property till 8/9, and then appropriate order can be passed. He has not considered many factual and legal aspects of it.
Relating to limitation laws.
Many things. There, so he has recorded all the submissions and straight away come to the conclusion. Many aspects have not been considered, legal and factual. Disposed of with their procedural observation. If you order to set aside,
For refer to the special mediation drive and cases item 4, second appeal 135 of 2022.
yes, please.
But my lords, notices have not been issued in this matter. It is not yet admitted.
But as I am informed, the authorities, they are issuing the notices.
I have no issue. This matter may be referred.
If it can be right, if they can issue the notices, it would be better. At the instance of the counsel for the petitioner, then this matter be placed before mediation.
Appearance de
From daily list for final disclosure item 2, second appeal 315 of 2016.
Defendant's appeal. NCID. What is the substantial question of law? Yes.
Although father of Muslim died in the life of Muhammad. Even in the plain Muslim
Just a moment. Now, let us see the plaint and the prayer made. Plaint and notices.
number 64 for you.
What was the suit for?
Suit for I claim for partition by the 4 plaintiffs.
Who is the common ancestor? Who is the common ancestor?
Plaintiff number 1 claim for 1/4 share.
Who is the common ancestor?
The common ancestor, his name is Ali Muhammad Khan. That also you see the page number 2 of the plaintiff.
Ali Muhammad Khan. Along with the decree itself, along with the judgment, this has been given. The genealogy has been given.
Yes, sir, that will be given already.
Okay, let us see. Is there any dispute on this?
No, that is not in dispute.
Okay, now let us see.
Let us see the plate lordship. What
Oh.
it is.
Just a moment. The matter is regarding Mohammed Yasin Khan, right?
Yes.
Yasin Khan. Where does he
Mohammed
figure?
Yasin Khan lordship is see plate of the page number 2 lordship. Mohammed Yasin Khan is the predeceased son of one Muhammad Khan.
Mohammed Yasin Khan.
Yes, lordship.
Okay, when did he die?
That has not come on record when he died. But in the plate itself, in paragraph 7, it was stated that the Muhammad Khan died leaving behind his two daughters, namely Bibi Mukarrabin and Bibi Musalim, and a widow Jainun Nisa, a son Salahuddin Khan, and two daughters Bahida Bibi and Sabila Bibi of his predecessor, Muhammad Yasin Khan.
You see, there is one Yasin Khan. There is one Muhammad Khan. Who is the person we are talking
Muhammad
about?
Khan is the father of Yasin Khan.
Just a minute. We are concerned with death of Yasin Khan. We are concerned with death of Yasin Khan.
Yasin,
Whether he died before his father or he died after his father.
that before his father. That has come. The paragraph says. That has come that the Muhammad Khan died leaving behind his two
Muhammad Khan, ये तो Muhammad
Khan
Khan.
is serial number 2. Ali Muhammad has 4 sons. Muhammad Sharif, Muhammad Khan, Muhammad Iltab, and Muhammad Bajuddin. If we come to the table of the Muhammad Khan, it comes Muhammad Yasin, Ali Muddin, Najmuddin, Mujahid, and Muqabil, Bibi Musali.
इसमें यासीन का नाम नहीं है. जो आपका प्लेंट है इसमें यासीन का नाम नहीं है.
Yasin नाम ही दिया है.
Where is it?
Yes.
In the plate?
itself.
In the plain
Yes, Lord. Yasin नाम ही दिया.
बताइए इसका नाम.
Lordship come to table of the Muhammad Khan.
मोहम्मद खान.
Yes, नीचे Lordship it has been given figure. Muhammad Yasin Khan. Then Ali Muddin. Then Najmuddin. Lordship is good. और I have figure 8.
That means you have Sharif, Muhammad Khan, then Muhammad on the next page. Muhammad Khan.
I have just marked it.
कितना है सर?
Nine plate is page number 2. A type copy is page number 2. In the top itself.
He is Muhammad Khan.
Yes.
Where is the name of Yasin Khan?
Yasin Khan will be below the name of the Muhammad Khan.
अच्छा ये
Yes,
Yasin
Lordship,
Khan.
that is it.
Okay.
Son of the.
What does para 7 of the plain say?
Paragraph 7 says Muhammad Khan died.
ऊपर से पढ़िए.
Yes.
para 3 पढ़िए.
That Ali Muhammad Khan died after few years
Before.
of actual service.
Before. यहाँ पर amend हुआ है. Ali Muhammad Khan died before. This has been amended.
After few years of actual service, living there is portion. Isolated geographical table. Who donated the entire landed property left by their Then Muhammad Sharif Khan died living behind.
नहीं उसके बाद and the above land are recorded in their name during cadastral survey. Unamended plaint मत पढ़िए भाई, ऐसा तो बहुत गड़बड़ हो जाएगा. पढ़िए आगे 4 नंबर पढ़िए.
Here we are concerned with the Lordship of the Sharif.
आप you may be concerned only with paragraph 7, but this court is not concerned only with paragraph 7.
Then
Right?
also it has come with paragraph.
इतना obsessed मत रहिए para 7 से. थोड़ा सा पढ़िए.
That
छोटा सा क्वेश्चन ऑफ लॉ है, ज्यादा नहीं है. ठीक है?
That is
4 नंबर पढ़िए.
that Muhammad Sharif Khan died living behind him only son. Ashuddin Khan and daughter Bibi Nazima, who jointly inherited the 1/4 share of their father Bibi Nazima, died leaving behind no issue. So her entire share given upon his only brother Ashuddin Khan, who became entitled for 1/4 share. Ashuddin Khan also died leaving behind him two sons. The son of 5 and 6 of these who inherited the entire 1/4 share. It was Bajuddin Khan died leaving behind him only son Kalamuddin Khan, who through himself sold it. Number 328/6/25 sold the entire 1/4 share to Baida Bibi, that printing number 1, who had in position of the same. A name for 1/4 share has been mutated by the federal government. This one case number 6/27. As he regularly claimed to the state of Delhi that Muhammad Aldaf Khan died, leaving behind him with 2 sons and 1 daughter. I saw his vertical table behind him with 2 sons at the time of 2. So here Muhammad Aldaf Khan depend on 1 2. That Muhammad Khan died, leaving behind his 2 daughters, namely Bibi Mukajavi and Bibi Musali, and a widow Jaibu Nisa, a son Salahuddin Khan and 2 daughters Bahida Bibi and Sabila Bibi, of his predecessor Muhammad Yasin.
So Yasin Khan, according to the plaint, he died prior to Muhammad Khan.
That is the question of that. Then comes section 52 of Muhammad. What it says.
लाइए तो मोहम्मद का written statement में क्या है इनका?
But I was not the party in the suit. I had filed the procedure
Okay.
from the legal of Muhammad Khan. We have filed the application for imprisonment. I was imprisoned as a party. We have purchased property in 1967. Then the said Muhammad Khan sold the property to his daughter, that is Musuddin Khan. Now come to section 52.
Just a
Partition.
minute, just a minute.
The very short question involved here.
Okay, एक सेकेंड हमको समझने में टाइम लगता है, थोड़ा स्पीड कम, थोड़ा इत्मीनान से।
Let us first state the plain entire agreement. Then I come to
Para 7 was denied in the written statement. Now, para 7 having been denied, I want to know what is the finding of it.
but the court they also come to the point that Yasir Khan is predecessor from his father.
Where is that finding? Finding दिखा दीजिए। ट्रायल कोर्ट का इश्यूज में आई है।
I should be.
इसमें तो कोई ये इशू नहीं बना।
Paragraph 11 is there. That the one could say if we have the trial court judgment itself also.
para 11
The one could say Muhammad Yasin had a living son named Yasin. He died during the lifetime of his father, leaving behind his widow, wife,
ये
children,
तो
son.
प्लीडिंग को ही रेफर कर रहा है ना।
That is the pleading.
But there was a dispute, right? अगर dispute नहीं होता तो अभी तुरंत हो जाता, कहानी खत्म।
Dispute है ही
But
नहीं.
there is a dispute. Therefore, I want to see the finding and the discussion.
Now come to the findings. issue number 5, 6 and 8 has been discussed by that time.
Finding लिखा है।
Actually, the finding about the partition is paragraph 20.
So it was the case of the plaintiff themselves that he has died. So they cannot argue against themselves.
Against that. The deputy clearly barred that during a lifetime of the
Mohammedan law का दिखाइए 54.
birth right was recognized. The right of an heir apparent or presumptive come into existence for the first time on the death of the recipient. And he is not entitled until
They are tenant in common. They are tenant in common. Unless there is death, it will not devolve.
birth right was recognized. That's why only the surviving legal heir would get the share. That is also says in Section 53 is also same thing also. When children are entirely excluded from the inheritance by their uncle and their
Just a
son
moment.
of the deceased son,
This is section 54, 53 and 54.
52 and 53. The son of the deceased son is therefore no time player.
हाँ सर क्या बोलना? Yes sir. What do you have to say?
But there was previous partition in between the co-sharers. In the year 1984, which is taken note by both the courts below, and therefore you also will find from the findings
Previous
of
partition
the
in
trial court.
just a moment. Previous
Previous
partition
partition between co-sharers
of
the landlord, of the original recorded deed.
original recorded deed.
Yes.
Four brothers.
Yes,
Previous partition on
yes, I am giving the date.
1984.
1984.
Okay, where is the finding that there was a previous partition?
Yes.
And did any property devolve on Muhammad Khan?
Muhammad Khan, one court share that has been taken note by the trial court as well as by the appellate.
Okay, where is that finding?
I'm not
Previous
again allowed to read the entire finding,
Yes.
which is on the main issue number 5, 6 and 8, which is at page at para 28, running page 46, internal page 8 of the trial court.
Okay. Yes, please read.
May I take it?
Sir, एक बात बताइए. The point of law is very limited.
Very simple.
So upon death of Yasin Khan prior to his father, the property will not devolve upon his legal heirs
Like
and
this
assets.
question does not arise in the facts and circumstances of this case, which I will show from the finding of both the courts below. Because your lordship has come to the plate only in the written statement, something has been admitted, which your lordship will get in paragraph 28.
Okay. Let us see paragraph.
While dealing with issue number 5, 6 and 8.
Let us see paragraph.
Yes. May I take it?
Yes.
Issue number 5, 6 and 8. These three issues are most important issues, therefore I took them together to consider first. In this suit, it is admitted by both the parties that Muhammad Ali Khan had four sons, namely Muhammad Iltaf Khan, Muhammadin Khan, Muhammad Iltaf Khan and Muhammad Wazuddin Khan. They are cadastral survey record area of suit plot number 524 area 1.30 acres along with other lands. In this suit, only plot number 524 area 1.30 acres is dispute. In support of the above contention of the plaintiff have filed cadastral survey Khatian with respect to suit plot number 524 area 1.30 acres. It is exhibit 2. I went through the above Khatian exhibit 2 and found that version of both parties are correct. In this suit, it is also admitted by both the parties that the partition had taken place among 4 recorded rayats, that is 4 brothers. Para 30. The plaintiff accepted the above partition, but this suit land had not been partitioned among 4 brothers. Therefore, each brother have 1/4 share in the suit plot. Accordingly, their one brother Wasuddin Khan had 1/4 share in suit plot number 524 area 1.30 acres. Wasuddin Khan died leaving behind a son Kalamuddin Khan and a daughter Kairu Nisha. The plaintiff number 1 Vaida Bibi purchased 1/4 share from Kalamuddin Khan, that is the defendant number 9.
Defendant was purchased.
Now that she came into joint possession over the suit
No, I
land.
don't get it. The plaintiff number 1, Wahida Bibi, purchased 1/4 share from Kalimuddin Khan. That is defendant number 9
Yes.
through registered sale. The plaintiff purchased it from the defendant. number
Yes.
9.
A defendant is also purchased. Plaintiff and defendant both are purchased from different persons.
Okay. आगे बढ़ते हैं.
She came into joint possession over the suit land and cultivating the land jointly according to her convenience. In this way, she is entitled to partition the suit land, and the pleadings of the defendant are untrue, that they are not in possession over the suit land as pleaded in their written statement. In support of para above contention, the plaintiff number 1 has filed original registered sale deed number 133806 dated 25/8/1970 as exhibit 1. She also pleaded that she muted in her name, which is recognized by the government. In support of this contention, she filed order of the Learned Commissioner South Chota Nagpur Division Ranchi as exhibit 3A, and from the above referred documents, plaintiff number 1 definitely entitled to get 1/4 share in the suit land. In this suit, I would like to mention here that there are 12 defendants in this suit, out of which defendant number 1 to 9 are the heirs of 4 above recorded rayats, and defendant number 10 to 12 are purchasers from the heir of Muhammad Sarif Khan and Iltaf Khan. They clearly pleaded in the written statement that the partition has taken place among 4 brothers, among 4 above brothers recorded rayats in the year 1934, and partition have taken place by meets and bounds by giving
Region.
regions and from above partition. The suit plot 524 area 1.30 acres have been given to Muhammad Sarif Khan and Muhammad Iltaf Khan, and in lieu of suit plot, other lands have been given to rest 2 co-sharers, Muhammadin Khan and Muhammad Wasuddin Khan. Therefore, Muhammad Wasuddin Khan has no share in the suit plot due to above reason. Therefore, Wasuddin Khan had no right to sell the 1/4 share in the suit plot of the plaintiff number 1. Her sale deed is invalid. It is not operative up till now. She never came in possession over the suit land as pleaded in the plaintiff. Her version regarding suit plot is totally wrong. The defendant number 1 to 9 belong to the family of recorded rayats. Hence, they are competent persons to clarify the mode of partition among their 4 brothers. defendant number 1, 2, 3, 5 and 6 failed filed written statement, but they have to come to support their written statement before the court. Although they filed written statement in favor of contested defendant number 10 to 12, in this present scenario, defendant 10 to 12 are the real contestants. They claim their title and possession over the suit land. Therefore, it is their liability to bring defendant number 1 to 8 before the court to state the real fact regarding above partition and possession, but they did not do so. It goes against the contested defendants. Even then, they could not state their non-appearance before the court. The contested defendants asserted in their written statement that they are real purchasers of the suit land from the real allottees, heirs of Muhammad Sharif and Muhammad Iltaf. Normally, it is presumed that 4 recorded rayats have 1/4 share each in the suit land, but in the present suit, defendants have pleaded in their written statement otherwise. They said that only 2 recorded rayats, that is Muhammad Sharif Khan and Muhammad Iltaf Khan, had got share in the suit property. Therefore, they have liability to prove partitions as alleged by them. The plaintiffs referred to ruling in support of above contention. I went through the ruling, that is 1999 volume 3 PLGR 378 para 3. I do concede with the above ruling, clearly contested defendants have to prove partitions as alleged in their pleading. If partition is proved according to the pleading of the above contested defendants, then they are entitled to get their purchased land and the plaintiffs will be ousted from the suit land. In support of partition as pleaded by the contested defendants, the following arguments was advanced. Muhammadin Khan, who is one of the co-sharers, had sold his share in favor of a daughter, Muslim Bibi, through sale lead number 747 dated 24/6/1967, Exhibit B/1. They told that the suit plot was not given in the sale deed. It proves that the plot is so not allotted to him, Muhammadin Khan and Vasuddin Khan Vasuddin Khan. The learned lawyer for the contested defendants.
That is something added.
Yes, there is some handwritten. I perused the sale deed Exhibit B by 1 and found that the dispute plot was not included.
But it is not proof of
Partition.
partition as stated in the written statement. The learned lawyer for the contested defendants argued that a partition suit number 35 of 84 had been filed before sub-judge among the heirs of opposite 4 co-sharers. The defendant number 1, Nayaz Ahmad Khan, of this case was the plaintiff, and the plaintiff number 1 and 2 and her vendor Kalamuddin Khan were defendants. They filed a written statement that partition had taken place of their entire land, that is including suit plot and the entire Rayati land of 4 recorded Rayats, were divided by metes and bounds by giving riches among co-sharers. In support of the above contention, they filed the written statement as Exhibit C to C/2 from the bare reading of these written statements. It is quite clear that the partition of entire properties of 4 recorded Rayats had been taken place, and partition had been taken by metes and bounds among all co-sharers, and they were coming in possession according to the partition as stated in the written statement, Exhibit number C/1 and C/2. The defendants have submitted that from the above Exhibit C1 and C2, it is admission of the plaintiff that the partition had taken place of entire lands, including suit land. Therefore, the plaintiff number 1 should not purchase the suit land as share of Vasuddin Khan from his son Kalamuddin Khan. On the above point, the plaintiff learned lawyer submitted that the statement given in another suit, which is
already dismissed.
In default, is not binding for this suit. It is not admission of plaintiffs. In the other hands, regarding admission, it cannot be normally used as conclusive evidence against the person making same unless she is given a change to know about and explain the same particularly when the admission is used for denying, taking away an valuable right or title in an immovable property. For proof of the above contents, the plaintiff cited 2006 4 JR, page number 706. I went through the above exhibit ruling thoroughly and found that the suit plot is not included in the partition suit 35 of 1984. Therefore, so-called admission of the plaintiffs and other related persons are not so relevant to reach through the facts of the suit plot has also been divided. The share in the suit plot was purchased,
No, I don't get it.
divided. The share in suit plot was
Therefore, so-called admission, and you read this. Therefore, so-called admission.
therefore so-called admission of the plaintiffs and other related persons are not so relevant to reach the truth of facts of the suit plot has also been divided.
That the suit plot has also been divided.
Yeah.
This suit plot is not mentioned in the partition suit. It was
But-
not
but-
included in the partition suit.
Let the substantial question of law which has been framed is relevant for the purpose of partition between two sharers, not between the purchasers. Purchasers found the
Purchasers are taking the
purchaser.
property from co-sharers.
I am coming to that. The purchasers have purchased the property which were in possession of their vendors.
That's
In
right.
partition of 1984.
In the partition of 1984 partition suit, this property was not included. This is the finding. If this property was not included, therefore it
Think
is.
of that.
Therefore, it will be subject to partition.
I may be allowed to refer the subsequent
And this
paragraph.
particular written statement and the paragraph, was it put to the defendant?
The defendant's claim was also rejected in the preceding paragraph. But now will it allow me to
इसको
give
read-
subsequent
इसको complete
statement?
करिए, इसको complete करिए.
Subsequent statement.
The 1/4 share suit plot. पढ़िए.
Therefore, the suit plot exhibit number-
I don't get it. If this plot was not included, then
Yeah.
how does the court come to a conclusion? Therefore, the suit plot has also been divided. How the court comes to this conclusion if this suit clause was not included? in
Therefore,
the-
will it, there is some discrepancy in this paragraph. Let me allow
Yes.
to read other
Okay.
paragraph.
And
Hence,
the 1/4 share in the suit plot was purchased.
Yeah.
lot was purchased in the year 1970 as Exhibit 1. So, hence, this so-called admission are not relevant. I contested their arguments and pursued the pleadings and considered the pleadings. I considered their arguments and pursued the pleadings and Exhibit C to C2 and found that suit plot was not the subject matter. In PS number
This, I think there is an
35
error
or
over there.
84.
Ultimately,
Now-
the finding is that it was not the subject matter of the partition.
Yes. Now will it allow me?
the defendants have submitted that heirs of recorded rayats used to sell frequently of their shares of land to different persons, and in support of above contention, the defendants filed registered sale deeds as Exhibit B to BA. It is proof of partition on this point that plaintiff's learned lawyer submitted that it is admitted by the plaintiff that partition has taken place for recorded rayats of their entire land earlier except only disputed land. It has not been partitioned. Therefore, Exhibit B9 do not help to prove the case of the contested defendants. I also went through Exhibit B series and found that Exhibit B, B1, B2, B3, B4, B5 and B6 are title deeds of defendants, and Exhibit B7 to B9 shows that transferring of rayat land was prevalent in their family. But the purchase of the plaintiff number 2 is prior purchase of defendant.
Plaintiff number 1.
Yes.
But the purchase of plaintiff number 1 is prior
Prior.
purchase of defendant
आगे से क्लियर हो जाए। We proceed.
Yes.
The learned lawyer of contested defendant submitted that they purchased disputed land through exhibit B3, B4, B5, B6. All the above documents are more than 30 years old, and those registered sale deeds were not challenged by the plaintiffs or the heirs of vendors. The mutation has done in favor of purchasers. Contested defendants, they filed government rent receipts as exhibit A to A6. On this point, learned lawyer of the plaintiff submitted that the mutation orders regarding suit land in favor of contested defendants are declared as reversed and set aside in support of the above contentions they filed. And the order of the learned commissioner, South Chota Nagpur Division Branch, as exhibit 3A, and he also submitted the title suit number 35 of 1984 has been dismissed in default of rent receipts. Exhibit A to A6, so filed in this suit, is now no relevant for this suit, and the plaintiffs filed exhibit 3B in support of dismissal of PS number 35 of 84. I went through the above referred documents and found that really the mutation order which was passed in favor of contested defendants has been declared and reversed and set aside. Therefore, the contested defendants cannot
See,
take.
the earlier partition suit was dismissed for default. A written statement was filed stating that or maybe in the state records.
But the
This
document
particular suit property was not the subject
not
matter.
party.
So what is the consequence? It means that there was no partition.
But there is this partition suit is not partition between purchaser and the party. They got it. There are dispute between purchasers. Now it
Maybe
will
they are deriving from the
It
court
will
errors.
clarify from the subsequent paragraph that what right vendors have to sell the property to plaintiff. It will come.
Therefore, the contested defendants cannot take the benefit of government rent receipts or other orders of revenue offices. The learned lawyer of contested defendants submitted that contested defendants and their vendors were or are in possession over the suit plot as a real title holder. They are coming continuous possession over the suit land except 18.5 decimal since more than 30 years. This 18.5 decimal land was acquired by the PWD department for the purpose of construction of Daltonganj Garwa Pakka Road. In support of our contentions, they filed Divisional Survey Khatian as Exhibit D. On this point, learned lawyer of the plaintiff submitted that those Divisional Survey Khatian are not finally published, therefore it cannot be used as evidence of title and possessions of the recorded rayats. In support of this contention, he filed 1997-1 BLJR 72-76 submitted that this judgment shows that Khatian issued under Section 83 Chota Nagpur Tenancy Act does not give presumption unless the same is permanently issued. I also used the above revisional survey Khatian and found that was this issued improperly. So Exhibit D is not ample relevant document to establish the right, title, interest and possession over the so-called purchase dispute.
Now that defense oral evidence of defendant was considered, kindly come to next paragraph.
Para 37.
37 में statement है different defendant.
पढ़िए ना para 37.
Para 37. The contested defendants examined altogether 11 witnesses to prove their case. Defendant DW 8 to 11 are found witnesses. They provided the Khatian repair in their names and showing their position. Raised witnesses are material witnesses. DW3 Rameshwar Mistry, he is the defendant number 12 and DW7 is Lallan Thakur. He is the son of Rambadan Thakur, defendant number 10. The two witnesses are most important witnesses, so I took it first to consider, they should make clear that what plot was allotted to Wasuddin Khan in lieu of the disputed plot. It is only point in controversy in this case. But from the careful perusal of the entire evidence of both, it could not be clear. However, the perusal of cross-examination para 49 and 50, 49, 50, 51, 52, 53 and 56 of defendant number 12 and para 23 and 24, it is quite clear that he has no good knowledge about partition among recorded writers. The defendant witness number 1, Khurshid Alam, DW1, Raju Khan, DW5 are material witnesses. I perused their deposition and found that they also could not disclose the clear position of partition among 4 riots. They also did not speak that such and such plot were allotted in lieu of disputed plot 2 Mohammadin Khan and Wasuddin Khan. In this way, it does not prove the fact that disputed plot was allotted to Muhammad Sharif and Muhammad Iltaf Khan in the said family partition. Therefore, the contested defendants are not able to prove the partition as pleaded in the written statement. Hence, Wasuddin Khan has 1/4 share in the disputed plot number 524, area 1.30 acres. In this way, other 3 brothers also have share in the suit plot. The suit land was not
So partition was disbelieved
Yes, definitely.
completely. This is the small finding.
Yes.
Therefore, the contested defendants are not able to prove. And ultimately, it was held that there was no partition amongst the 4 brothers.
In 1984, there was no partition.
There was no partition. Then,
It is mentioned by the contested defendants at the time of arguments that Wasuddin Khan had not only a son Kalamuddin Khan, but he had a daughter Kairu Nisha also, and after the death of Wasuddin Khan, his son and daughter inherited the share according to prevalent Muslim law. But son of Wasuddin Khan, namely Kalamuddin Khan, had sold entire share of his father's lonely to plaintiff number 1, Wahida Bibi. The plaintiff gave the name of Kairu Nisha in genealogical table, but the plaintiff did not disclose her share in the plaint. Even she is not named party. According to Muslim law, she had share in his father's share. The plaintiff has not purchased plaintiff number 9. 1 has not purchased her share, hence the sale lead exhibit 1, which is in the name of the plaintiff number 1, is valid to the extent of share of Kalamuddin Khan, that is 1/6 share and not 1/4 share. The daughter of Wasuddin Khan, namely Kaira Nisha, has 1/12 share in her father's share. Other 3 brothers of Wasuddin Khan have 1/4 share each in the suit plot. Therefore, the heirs of Muhammad Sharif Khan, Muhammadin Khan and Iltaf Khan were or are entitled to sold to the extent of their family share only. From the evidence and pleadings of the contested defendant, it is clear that total disputed area is not 1.30 acres, but it is only 1.30 acres to 18.5, that is minus 18.5, that is 11.5 acres, because 18.5 acres was acquired by the PWD to construct Pakar Daltonganj Garwa Road. In this way, only 11.5 should be divided among 4 recorded riots. 1.11.5 should be divided among 4 recorded riots. 1.11.5 by 4 equals 2 acres each according to value and convenience of the parties' purchases. Now the defendants 1213 for that purchase 21 acres is disputed plot number 524. Muhammad Sharif Khan, that is Arshuddin Khan, he is the father, so he is entitled to get 1/4 share plot. Hence, he sold the land with his share dated 25/3/74, which is Exhibit B3. This B3, this purchase. This purchase is valid.
इसको
सब आपने
आफ्टर 40
क्यों पढ़ रहे हैं?
फिर आप
Why are we reading so much?
नहीं वो इसमें पूरा हुआ है para 40 से पढ़ रहे हैं
Now the defendant 1213 for that Bagru M. Mistri purchased 21 acres in disputed plot number 524 from the son of Muhammad Sarif Khan, that is Arsuddin Khan. He is the only son of his father, so he was entitled to get 1/4 share in the suit plot. Hence, he sold the land within his share through sale deed dated 25/3/74, which is Exhibit B3. This purchase is valid. The contested defendants pleaded in pleading that only 1/4 share was Muhammad Ziltaf Khan. He had two sons, namely Maruza and Niaza Ahmad, and a daughter Taslima Sol Kumaru Jama had sold his 2 anna share in favor of her wife Mursaleen Bibi through Exhibit B2 on 1.1765, and after this Mursaleen Bibi, defendant number 8, and Niaz Ahmad, defendant number 1, sold jointly 30 decimal land in disputed plot to the father of defendant number 12, Rameshwar Bishkarma, on 18/9/1973 through Exhibit B. I perused Exhibit B2 and B and found that disputed plot 524 was not sold by.
Sir, हमको कुछ समझ नहीं आ रहा. He is just reading it. He is उनसे भी पूछेंगे तो उनको भी कुछ समझ
नहीं नहीं पूछे
ऐसे substantial question of law का कितना impact है वैसे
कोई impact नहीं है. That is what I submitted at the very inception. कोई impact नहीं है उस substantial question of law का. It was just being substantial question hard and formulated.
whether the plaintiffs are entitled for partition. They are entitled for partition. It has been held that there was no previous partition. They are entitled for partition. Although the father of the plaintiffs, Muhammad Yasin Khan, died,
Each and every party was selling.
the plaintiffs के all the plaintiffs के father Yasin Khan. Was Yasin Khan the father of all the plaintiffs?
Yes, that is fine.
Right. So Yasin Khan had died prior to Muhammad Khan, right? And there was no previous partition.
There was no previous party.
So therefore,
according to their share, because each and every party were selling the property which has come in the evidence, and this party is also selling his property to plaintiff. इसका allow किया जाए हमको थोड़ा सा पैराग्राफ रह गया है बस 5
एकदम ऐसा लिखा हुआ है जजमेंट में कोई फ्लो नहीं.
उसी में से क्या करेंगे उसी में से नहीं निकालना है.
There is no flow in the judgment. He is just reading it. उनको खुद समझ नहीं आ रहा. सर आप पढ़िए हम ऐसे नहीं परमिशन देंगे. A person who is not able to understand, बताइए तो क्या समझे? पूछिए.
नहीं इनको ये तो
नहीं सर ऐसे जब भी कोई पढ़ते हैं ना तो
ये तो
उसको एक अंडरस्टैंडिंग होता है and that reflects while arguing.
he is just new. एक मिनट अलाउ किया जाए.
सर जिन्होंने घर में एक बार भी नहीं पढ़ा उनको खड़ा कर दिया यहाँ पढ़ने के लिए.
ये पढ़े.
This is not done.
ये तो रीडिंग देना था इसलिए.
कम से कम जो भी जूनियर पढ़े हैं आपकी तरफ से
नहीं होना
कम से कम घर पे तो 2 बार पढ़ के आना चाहिए.
अभी 5 मिनट के लिए ऑर्डर्स केसेस में कहते हैं नहीं पढ़ के आए. ये पढ़ के आए.
ये तो पढ़ के
बताओ.
आपको कोई भी चीज पढ़ना आपको मना नहीं कर रहे. घर पे समझ के पढ़ के 3-4 बार पढ़ना होता है. ऐसा नहीं एक बार में पढ़िए. स्टोरी बुक नहीं है ये. ठीक है. कौन किसको ट्रांसफर चार्ट बना के लेके आना है. कौन किसको ट्रांसफर कर रहा है, कितना पोर्शन ट्रांसफर कर रहा है, किसका शेयर ट्रांसफर कर रहा है. ऐसे पढ़ने से तो ना हमारे तो कुछ समझ नहीं आ रहा.
My friend will clarify this situation.
Lordship, on earlier occasion, 1934, the land was partitioned between the 4 sons of the recorded.
1934.
84 का disbelief है.
Except for this plot. Except for this plot, all other plots were partitioned.
Where is that finding? That 1934 में
Yes, Lordship.
except for this plot, all other plots were partitioned. Yes, बताइए कहाँ है? So there are 2 partitions.
Yes, sir.
Yes.
This is the second partition we are claiming, and before this it was in 1934. In the plate also we have stated, Lordship.
1934 previous partition, but suit property was not.
This suit plot was not included.
ये पारा 10 of the plate में
नहीं ठीक है, हम आपकी बात ले रहे हैं, तो वो तो आएंगे अपना बताएंगे, ठीक है। उसके बाद 1984 के पार्टीशन को डिसबिलीव कर दिया,
That
तो
was
वो
dismissed
DFD हो गया, राइट। 1984 पार्टीशन
because that was dismissed for default.
was disbelieved. In 1984 में जो पार्टीशन हुआ था, it was amongst whom? क्योंकि 1934 में तो पहले पार्टीशन हुआ।
In that also this suit plot was not included. And
It was amongst whom? हो सकता है it is in one of the branches because पहले पार्टीशन हो चुका है।
Lordship, we were the defendants over there.
It was amongst whom? जब 34 में पार्टीशन हो गया, तो ब्रांच का अलग-अलग पार्टीशन हुआ होगा। ये सूट ब्रांच के लिए फाइल
Yes,
हुआ
sir,
होगा।
Lordship. उसमें हम लोग defendant थे, हमने ये बोला है कि the suit plots mentioned in that partition suit has been partitioned by meets and bounds. But since this was not included in that suit, hence we have not mentioned anything about
No,
this
no.
part.
You see the suit plot which was all the entire property was divided in 1934 except the suit plot.
Yes.
तो पार्टीशन के लिए कौन सा सूट बचा, प्लॉट बचा था, यही वाला।
Yes, sir.
But this was also not included.
This has been included in this suit. In
It
that
was not
80
included in
Yes,
1984.
sir, Lordship. We had not filed that suit, Lordship. We were the
84
defendants.
का पार्टीशन तो डिसबिलीव कर
उसको कहानी छोड़
dismissed for default. 34 वाले में ये included नहीं था.
34 में included नहीं।
This plot has been recorded in the name of all four brothers. Only this plot.
Okay. All this plot has been recorded.
In the name of all four brothers of four sons of recorded tenant. It is Lordship Mohammed Sharif Khan,
4 sons of recorded tenant. Okay.
Mohammed Sharif Khan, Mohammadin Khan, Mohammed Iltaf Khan, and Mohammed
So
Wazuddin Khan.
this plot was never partitioned.
No, Lordship.
Okay. Now, when this plot was never partitioned, his case is that Yasin Khan, he died before Muhammad Khan,
Yes, Lordship.
right? And the plaintiffs are the legal heirs and successors of Yasin Khan.
Yes, Lordship.
If Yasin Khan died prior to Muhammad Khan, and with respect to this property, there was no partition, then the property continued to be of Muhammad Khan.
No, Lordship. So here we are claiming partition on the capacity of purchaser and not in the capacity of.
फिर मोहम्मद खान के कितने वारिसान थे उस जगह?
Mohammadin Khan died leaving behind Yasin Khan, who predeceased.
Okay.
Alimuddin Khan died issueless.
Okay.
Muzawin died issueless, and two daughters, Bibi Mokazabi and Bibi Mursali.
They were only left.
They left.
Now, according to Mohammedan law, in between Mohammadin and two daughters, residue will go to this Yasin.
Yasin's son.
यासीन के सन मतलब हो गए उनके सलाउद्दीन। आपके पास वो वाला अगर नहीं होती इसका कॉपी
Judgment में है, डिक्री के पहले.
डिग्री के पहले जजमेंट में है क्लियर।
भाई जब यासीन खान का डेथ हो गया मोहम्मद खान के पहले, तो मोहम्मद खान का कोई भी प्रॉपर्टी यासीन खान के ब्रांच में कैसे डिवॉल्व करेगा?
It will not go to Yasin's Khan branch. It will devolve upon Bibi Mokazabi and Bibi Mursali.
That's right. Okay, 2 persons.
In the top lordship,
Exclusively 2 persons.
one third and one third, maximum of one third in Muslim law lordship, to the daughters.
And the
No,
residue,
maximum means what?
हाँ,
What
and the
the
residue will go to भतीजा, उसके भतीजा।
ये कौन सा लॉ पढ़े?
ये मुझसे
Shares and residue.
कौन सा आर्टिकल?
अनिपी लो, अनिपी लो, एक चार्ट है मोहम्मदन लॉ में। how the Mohammedan property is partitioned between sons, daughters, and other residue.
It will go to the agnates.
Residual, ये रेसिड्यू बचा हुआ जो पार्ट
मतलब अगर मान लीजिए एक ही बेटी हो तो उसको 1/3 मिलेगा, कहानी खत्म।
1/3 मिलेगा, रेसिड्यू जो है
हाँ।
वो रेसिड्यू
उसके
जो है
चचेरे ममेरे भाइयों को
उनको
चला
जाएगा,
जाएगा।
उनको जाएगा।
कहाँ से?
वो क्लोजेस्ट डिग्री का भी डेफिनेशन है वो।
ये बताइए, ये कहाँ से आप बता रहे हैं? अगर एक ही बेटी रहेगी तो उसको 1/3 जाएगा और बाकी चला जाएगा दूसरों को।
रेसिड्यूरी का डेफिनेशन है 65 में।
If there are no sharers,
किताब नहीं होती,
जब-
किताब नहीं 65। Yes.
residuaries. If there are no sharers, or if there are sharers but there is a residue left after satisfying their claims, the whole inheritance or the residue, as the case may be, devolves upon the residuaries in the order set forth in the annex
No,
table.
what do you mean claims? Where is the law to say that the daughter cannot claim more than 1/3?
ये चार्ट में
ऐसे नहीं, हमको
ये
नहीं
चार्ट
समझ-
बना हुआ है,
हमको लॉ थोड़ी आता है। बताना
चार्ट
पड़ेगा
बना
कहाँ
हुआ
से।
है।
I will not
ये पढ़
assume
लेते हैं,
anything.
पढ़ लेते हैं।
आप हमको दिखाइए कि बेटी को ये 1/3 से ज्यादा मिल ही नहीं सकता, भले वो इकलौती बेटी हो तो भी नहीं मिलेगा। दिखाइए। और इनफैक्ट ये जो आप बोल रहे हैं कि 1/3 इनको मिलेगा, सर जब यासीन खान के डेथ के बाद मोहम्मद खान का कोई भी प्रॉपर्टी यासीन खान को नहीं इनहेरिट होगा, then under such circumstances the how the property will be inherited by him or through him with respect to with respect to 1/3 कैसे?
That is
जब तक यासीन खान के थ्रू नहीं डिवॉल्व करेगा तब तक कैसे?
यासीन खान को थोड़ी देर के लिए भूल जाएंगे।
भूल
The
भूल नहीं
property-
पा रहे ना, कैसे भूलेंगे?
The property went to Mujbin Bibi and Bibi
Yes,
Mursali.
half.
Not half, 1/3.
कहाँ से बोल?
Mountain law का है, just
आप बताइएगा पीलांच, आपका काम हमको तो नहीं करना है ना?
नहीं, अब बताइए, अब बताइए।
ये एक लिस्ट बनाना है और फिल अप 62 63 में शेयर्स का डिफिनेशन है, जिसमें 7 नंबर सीरियल करेंट डॉक्टर्स 1/2 if there is no son, when number 1 no son, daughter, higher sons, daughter or equal sons and daughter. नॉर्मल शेयर ऑफ 1, एक बेटी रहेगी तो हाफ जाएगा और 2 बेटी रहेगी तो 2/3 जाएगा बेटियों को। इफ देयर इज नो सन, व्हेन देयर इज ओनली 1 daughter or higher sons daughter but no sons, higher sons or equal sons, the daughter or higher sons daughter will take half and the sons daughter howsoever will take 1/6, that is 2/3 and half. With an equal sons and sons he becomes as a residuary.
इसको एग्जाम्पल दे के कभी बता देंगे, ये इसका जजमेंट मिलेगा कि बेटी अगर एक है या दो है तो किस तरह से प्रॉपर्टी डिवाइड होगा। इसको थोड़ी देर के लिए इसमें समय दे दिया जाए। अभी फिलहाल आगे बढ़ते हैं फाइटिंग, तो वो देख रहे हैं। ठीक है, उसको क्लियर कर देंगे। अकॉर्डिंग टू द schedule A, which has been annexed in the judgment itself.
Which we are claiming two shares, 1/4 share and 1/12 share. 1/12 share being the residuary, and 1/4 share we are claiming that we have purchased from Muhammad Wazuddin Khan. That is the fourth son of Ali Muhammad Khan. So his share is purchased by plaintiff number 1, Wahida Bibi. So we are claiming partition in the capacity of purchaser of 1/4 share.
The plaintiffs are the purchasers.
Wahida Bibi is the purchaser. Plaintiff number 2, Salahuddin Khan. He is claiming as residuary lordship that we have just referred. So 1/12 plus 1/4 share. 1/12 by inheritance, 1/4 by purchase.
1/12 by inheritance.
Yes, lordship.
How do you get 1/12?
Residuary lordship.
How does residuary?
Two daughters will be entitled to 2/3 of 1/4 share. 1/4 share.
2/3 of 1/4 share.
Yes, lordship. That will be, what is that? 1/6. Thereafter, the whatever has been left, that will be devolving upon the
1/6
residuary.
will be 5/6. Remaining will be 5/6. How do you get 1/12?
One by 6. Yes, lordship.
1/3.
तो 1/12 कैसा है?
And the share of Lord Muhammad was of the total 1/4. दो तरह से प्रॉपर्टी एक्वायर की।
वो 1/6 भी होगा लॉर्डशिप. Then after that, what will be left of 1/4 will be 1/12 only. जब वो 1/6 हो गया लॉर्डशिप, दोनों बहन का शेयर, then subtracting it from 1/4 we'll get 1/12.
पहले तो 1/4 हुआ मोहम्मद खान का, ठीक है? उसका फिर हुआ
Both
1/3,
daughters got 2/3.
फिर 1/3.
2/3 लॉर्डशिप including both daughters. जहाँ दो daughters है 2/3 होगा लॉर्डशिप अभी पड़ेगा.
ठीक है, तो
That
2/3 into 4 into 1/4. 1/6 आ गया.
1/6. Now 1/6 will be subtracted from 1/4 property to find the residuary lordship.
1/4 is the entire property.
1/4 is the entire property of Muhammadin Khan.
1/4 minus 1/6.
Yes, sir, lordship. That is 1/12.
1/12.
Now that residuary property has come will be in all three of them, but the other two have relinquished their share in favor of this son, Salahuddin Khan.
This has come. This evidence has come.
Plaintiff number 2.
Yes, sir.
So the entire would go to Salahuddin,
Salahuddin
plaintiff number 2.
1/12. Yes.
So he is claiming 1/12 plus purchase from.
That
What
plaintiff
you
number 1 is claiming purchase.
Plaintiff number 1 is claiming purchase.
As well as residuary.
Purchase plus residuary B.
Yes.
Plaintiff number 1.
Plaintiff number 2
है residuary.
Plaintiff number 2 is only claiming residuary.
Residuary.
That is 1/12.
Yes.
Plaintiff number 1 is claiming purchase से 1/4
Purchase से 1/4 of
पूरा ही बेच दिया.
from what's you?
Wazuddin Khan,
Wajuddin Khan.
year 1970.
Okay. अब दो ही plaintiff हैं.
और दो प्लेंटिफ थे, दोनों ने अपना शेयर रेलिंक्विश कर दिया इन फेवर ऑफ प्लेंटिफ नंबर 2.
Plaintiff number 3 was Waida की Khan है.
Another one was
So आपका कहना है यासीन खान अगर मर भी गए पहले तो शेयर तो इतना ही होने वाला है. वो पहले मरते
क्योंकि
चाहे वो अगर बाद में मरते तो इन लोगों का शेयर ज्यादा हो. Could be.
जाता. लेकिन हुआ क्या है कि हमको शेयर नहीं है, हम परचेज किए हैं और रेसिडुअरी से जो मिला है वो
Residuary से plaintiff number 2
प्लेंटिफ नंबर 2 को मिला
plaintiff number 1 only purchase.
only on the basis of purchase.
And this is what has been done by the court.
Yes. Now it therefore will allow us to read further finding of the charge.
नहीं इसको
हाँ क्लियर हुआ कि नहीं?
एक सेकेंड. हाँ क्लियर हो गया. लिखने दीजिए ना, फिर भूल जाएंगे. The genealogy given in Schedule A is not in dispute. The property originally belonged to Ali Muhammad Khan, and except the suit property, there was a partition amongst the 4 sons of Ali Muhammad Khan way back in the year 1934. And the suit property was recorded jointly in the name of 4 brothers in the Khanyan also. The claim of previous partition of the year 1984 has been disbelieved by the courts. It is not in dispute that Yasin Khan had expired prior to his father Muhammad Khan. And therefore, after death of Yasin Khan, none of the property of Muhammad Khan devolved directly upon his legal heirs and successors.
Yes.
Yeah, Muhammad Khan had altogether 5 children. The other 2 brothers of Yasin Khan, namely Alimuddin Khan and Mujibin, they died issueless. And 2 daughters were left who were 2 daughters were left and were entitled to 1/3 share each as per Muslim law. And the remaining share of Muhammad Khan would devolve upon the children of Yasin Khan, who are the residuaries.
Yes.
The children of Yasin Khan were plaintiff number 1, 2 and 3 respectively. 1, 2 and 3. And so far as plaintiff number 1 and 3 are
Plaintiff
concerned,
number 4 is wife of
हाँ,
Yasin.
plaintiff number 4 is wife
Wife
of
of
Yasin
Yasin.
Khan. So far as plaintiff number 4 and plaintiff number 3 are concerned, they had relinquished their claim in favor of Salahuddin, and consequently he was entitled to their share. Plaintiff number 1 had purchased the entire share of Muhammad Waziruddin Khan, which was a son of Ali Muhammad Khan, to the extent of 1/4 share of the entire property. Accordingly, the plaintiff number 2, being the residuary, claimed 1/12 share. The calculation would be 1/4 into 2/3 नहीं 1/4 1/4 minus 1/4 into 1/3.
2/3.
Sorry, 1/4 minus 2/3. और इनको प्लेंटिव नंबर 1 को रेसिडुअरी का कोई प्रॉब्लम
नहीं,
नहीं
नहीं।
मिलेगा.
She is not asking by the right of residuary. She is directly asking for the property purchased by Muhammad Wadiuddin.
Has she also relinquished it? She has also
She had also relinquished.
Both sisters and mother.
both sisters.
Bahida and Saida, they are both sisters. And
Okay.
mother is Jerunation.
Okay. Both sisters, by plaintiff number 1 and plaintiff number 3 and plaintiff number 4 have relinquished their share in favor of plaintiff number 2. Yeah.
This is the law which has been taken note by trial court as well as by appellate court. But share में कुछ difference हुआ है. And regarding the law blood, we will clarify it soon after reading out the entire finding of the trial court. Para 41 में
बाकी तो इसमें कोई क्वेश्चन ऑफ लॉ ही नहीं है उसमें हम लोग क्या बोल सकते हैं.
हम तो पहले ही कहे कि क्वेश्चन ऑफ लॉ जो है इट इज नॉट रेलिवेंट फॉर द पर्पस ऑफ दिस सूट.
एपेलेट कोर्ट क्या किया?
यस नहीं जस्ट इसका फाइंडिंग ऑपरेटिव पार्ट ऑफ केवल दिखाना
ठीक है.
इशू नंबर 1, 2 and 9 at page 20. Transport.
1, 2 and 8.
Yes. How the share has been considered by the judge?
It is proved that the above suit land was not partitioned by means and bounds. The suit is enjoined among the heirs of recorded regates, and from perusal of the order of Learned Commissioner, South Chotanagpur Division, it is clearly directed the parties to go to civil court for just decision on the case. The plaintiff requested to the defendants to partition suit land amicably, but they have avoided. From the pleading and evidence of the contested defendants, it is clear that they asserted right title, interest and possession over the suit land. In this circumstances, there was only option for the plaintiff to file the above suit. Hence, the plaintiff have cause of action to the suit and the suit is maintainable. In purview of the above finding, in the circumstances, the plaintiff are not entitled to get other reliefs. It is therefore ordered that plaintiffs are entitled to get partial preliminary decree of the partition of suit land as stated above against the defendants with contest but without cost of the suit.
इसके पहले फाइंडिंग जो था therefore blood I was requesting for consideration on
Partial preliminary decree.
with respect to the observation made above. Here, issue number 5, 8, running page, internal page 90. Right? तो उसके पहले kindly have a look to para 43 internal page 17 of the judgment. यहाँ क्लैरिफाई किया गया है
ये बताइए शेयर कितना होगा इसमें.
Para 43. From the perusal of pleadings and evidences of the parties, it is quite clear that the suit should be filed in form of declaration of title and confirmation of possession, because the disputed land was purchased without looking into title or possession over the suit land by both parties. They are claiming title and possession through their registered sale deeds, that is Exhibit 1 and Exhibit B to B by 6, respectively. It is truth that first of all, the plaintiff number 1, Mahadi Bibi, purchased the 1/4 share of the suit land from the son of recorded 1/4 shareholder Mezuddin Khan. His sale deed is Exhibit 1 dated 19/8/70, and after this, contested defendants have purchased part of the suit land. Therefore, the sale deed Exhibit 1 is valid only to the extent of the share of a vendor prior purchase of defendants. Her name was mutated in regard to her purchase, although she is not entitled to purchase complete 1/4 share because Wazuddin Khan had a daughter also. She had or have in her father's share. The court declares her plaintiff number 1 title and possession over the suit land to the extent of a vendor's share, which is defined above. She has to pay ad valorem court fee in the suit value, which is given in the plain to the extent of her share. Regarding plaintiff number 2 to 4.
So just a moment. This person also had a daughter.
Yes, sir.
What do you think?
Oh, defendant number 9.
Yes.
Khairun Nisha.
खैरू निशा एक डिफेंड नंबर 9 कौन है?
वो उसका बेटा है लॉर्डशिप, जिससे हम लोग खरीदे हैं।
और जिससे खरीदे हैं। अच्छा, खैरू निशा का फिर 1/3 शेयर।
हाँ, इसमें वही बोला है कि 1/3
राजकोट का फाइंडिंग यही है कि वजीउद्दीन के शेयर में उनकी बेटी का भी हिस्सा होगा।
इसीलिए उन्होंने सिर्फ कमरुद्दीन का भी शेयर, लेकिन
शेयर
कितना
का।
हिस्सा होगा ये नहीं लिखा।
देखिए आगे है।
It is stated in the plaint and adduced evidence that plaintiff number 1 is the sister of plaintiff number 2.
कहाँ से पढ़े थे? कहाँ पे?
Next paragraph, page 18 में.
Page 18. Okay. Yes, please.
It is stated in the plaint and adduced evidence that plaintiff number 1 is the sister of plaintiff number 2, and the plaintiff number 4 is the mother of plaintiff number 1 and 2. They relinquished their share in favor of plaintiff number 1. It is accepted that plaintiff number 3 is also sister of the plaintiff number 1, but according to law, oral relinquishment does not create valid right, title and interest and possession over the suit land. In this suit, the plaintiff number 1, 3 and 4 have not come to support their version as evidence. Therefore, at present circumstance, the plaintiff number 2 is not entitled to get a share of his mother and 2 sisters. If they will execute registered deed of relinquishment in his favor, then he would be entitled to get their share. He is entitled to get only his share in the ancestor, that is Muhammadin Khan, according to Muslim law. His possession was and is also disturbed by the contesting defendants, although the defendant number 10 to 11 possession of the suit land is only valid up to the share of their vendors. Now the plaintiff number 1, 2, 3 and 4 are entitled to get share and possession over the same by mode of partition. In this way, the suit lot is joint and unity of title and unity of possession is sustaining. Therefore, the plaintiffs are entitled to get partial preliminary decree of partition regarding suit land. In this way, issue number 5, 6 and 7 are partially decided in favor of the plaintiff.
कितना शेयर? How
उसका
much?
शेयर कितना होगा? होगा कितना?
1/6 कर दिया उसको।
कुछ भी नहीं दिया है, कैसे कुछ डिसाइड ही नहीं किया कितना शेयर मिलेगा? भाई
नहीं
कोई
डिसाइड वो अपने कोर्ट किया है, वो क्लैरिफाई किया है।
ट्रायल कोर्ट तो नहीं किया है।
नहीं ट्रायल कोर्ट नहीं। कोर्ट बोले कि दैट इज द पार्ट प्रिलिमिनरी, बट व्हाट पार्ट दैट हैज नॉट बीन डिसाइडेड।
एपेलेट कोर्ट क्या किया? Salahuddin Khan is entitled to residue for 1/12 share in the suit land. 1/12. Yeah.
In a appellate court, 2 points were formulated in the certain basis.
Relinquishment को accept कर लिया है क्या appellate court?
Yes.
Relinquishment has been
And
accepted. Trial court तो नहीं किया है.
नहीं. Two points have been formulated in para 11 of the appellate case. Internal page 6.
From perusal of pleadings of the parties, the following points emerge for determination in this present appeal. Is there a unity of title and possession between the parties relating to the suit land, and whether the plaintiff number 1 and plaintiff 2 are entitled for 1/4 share and
Only 2
1/3
would be relevant.
Yes, sir. Both have been decided together.
ठीक है. Point number 1 and 2 in para 12 and on. And ultimate finding is that internal page 13 of that with respect to point number 1 and 2.
Four lines from the top I am reading.
Hmm.
PW6 Irfan Khan has proved the possession of Wahida Bibi and Salahuddin Khan on the suit plot, and also the fact that the suit plot has not already been partitioned by means and manner. DW1 Sheikh Khurshid has proved possession of Wahida Bibi on suit land, but has wrongly stated that suit plot is not recorded in the name of Survey Rayat, whereas Exhibit 2 has established the fact that the name of Survey Rayat is mentioned in the suit plot. This witness has no knowledge regarding Rayats of the suit plot and unity of suit plot. DW2 Raju Khan, aged about 28 years, has no knowledge as to who were recorded Rayats of the suit plot. This witness has stated that sons of Yasin Khan are in possession of several plots but cannot say plot number. Plaintiff number 2 is the son of Yasin Khan. DW3 Rameshwar Mistry is the appellant defendant in this case, has reiterated in his pleading, and in para 48 he has stated that the lands of Khata number 7 has not been partitioned in their presence. The learned counsel for the appellant has argued that no reason has been assigned from side of plaintiffs as to how suit plot has been left in the amicable family partition. Learned counsel for the plaintiffs have relied on the case law reported in so in which it was held that an heir can claim partition in respect of one of the property held in common without seeking partition of other property. This rule of law supports the case of plaintiffs who can claim partition for a single plot, that is suit plot. Moreover, the case of defendant appellant is that all the properties including the suit land have already been partitioned amicably, but this fact has not been supported by evidence adduced from the side of the defendant appellants. From the above discussion and after going through the evidences, oral and documentary, I am of the firm view that there is unity of title and unity of possession between the parties to the suit relating to the suit, and the plaintiff number 1, Wahida Bibi, is entitled for 1/4 share in the suit land, and plaintiff number 2, Salahuddin Khan, is entitled as residuary in residue for 1/12 share in the suit land. Therefore, point number 1 and 2
प्लेंटिफ नंबर 1 का फिर से 1/4 कैसा है?
बच्चे वो जो पार्टीशन सूट का जिसको डिसबिलीव किया गया था उसी के रिटन स्टेटमेंट में था कि फादर ऑफ दिस द अदर डॉटर हु had not executed the sale deed, she had been excluded from the property of her father, hence it entirely devolved upon my witness, that is Kalimuddin Khan.
Okay, ऐसा finding है.
Yes, yes.
Where is that finding?
Page 10 in the middle also. Page 10 about 10 lines from top. From perusal of exhibit C.
Yes.
From perusal of exhibit C, certified copy of written statement of Wahida Bibi, defendant number 1 in partition suit number 35 of 1984 in the court of Subject Balamu, it is crystal clear that in lifetime of Waizuddin Khan, Khairun Nisha was kept excluded from the suit property of her father. It is mentioned in the written statement, Exhibit C, on which the appellant defendant number 10 to 12 have placed reliance that during the lifetime when Muhammad Waizuddin had grown old, he had allowed his son Kamaluddin Khan to cultivate all the lands in his share. He loved Kalamuddin Khan, his only son, very much, and therefore 2 years before his death, which took place in the year 1944.
That's
He,
हाँ बोलिए क्या बोलना है?
My submission is Millard.
क्या आप तो इसका कोई रेलेवेंस ही नहीं है.
कोई
हम
नहीं
लोग ये एडमिट कर रहे हैं कि पहले डेथ हुआ. यस काउंसिल अपीलेंट आपसे पूछ रहे हैं. इट इज एन एडमिटेड फैक्ट दैट ही डाइड प्रायर टू. क्या बोलना है?
He had died prior to that.
प्रायर टू हिज फादर.
Not his father.
इसका क्या इम्पैक्ट?
Then his legal heirs do not entitled to any property.
सॉरी
Then his legal heirs do not entitled to any property. as we have shown in section 52 and 53.
And what about
Now-
this?
Now we have
Residuary property?
residuary will not go. If even if she said that a grandchildren, son of a PC son is therefore not an heir, then he is not an heir. That is also coming, section 53. Then he is not an heir. He is not entitled for any share, even 112 or 160.
He will not, since he is not one of the legal heirs, therefore the residuary will go to whom?
That is not a question.
That is a question. You see, the
Residuary.
daughter is entitled to 1/3
Yes.
maximum, right? So I just want to know if there is just one daughter, she will be entitled to 1/3.
That's why we have to see the other documents which show that the said Muhammad Khan has sold the property to his daughter also by of sale date.
No, we don't know.
They in 1965 itself.
No, that is irrelevant. You just tell us that in case of one daughter, only one daughter, what will happen? How much will she get? How much will she get? The entire property.
Then he will get after fulfill the debt.
Forget our debt का कौन बात कर रहा है?
That is not there.
बताइए, आप बताइए, आपसे पूछ रहे हैं.
The policy could first become the blend of the previous suit. In the previous suit also the property is included. Even in the return statement, the plaintiff number 1 himself admitted there is partition.
There is
There are
partition.
nothing
There is a finding that the earlier partition did not include this particular property. Where is the finding? वो छोड़ दीजिए आप. Where is the finding that it was included?
That finding not
Then,
but that
and
not
there is no substantial question of law on that finding.
no that
There is no substantial question of law on that finding. I will not hear you on
It
that.
is only one question of law. What is the right of a predecessor?
Yes.
It is father. That is covered by section.
He has no right, but his children also will have no right.
That is also come up. The son of a predecessor is also therefore not an heir. If he is not an
Which
heir,
has, from where are you reading it?
then 53 itself plus. First section 52, then section 53.
Read 52. Yes.
First article tells us 52 is first that right of an heir that we have read last. Second there is
पढ़िए ना, आधा सेंटेंस मत बोलिए और आधा बात मत.
so section 53.
52 पढ़िए पहले. Read 52.
The right of an heir, this section 52. The right of an heir, apparent or presumptive, comes into existence for the first time on the death of the ancestor, and he is not entitled until then to any interest in the property to which he would succeed as an heir if he survived the ancestor. Now, in the example they have given, what is recognized? Now, come to section 53. Principle of preference. Going to Sumil now. The expectant right of an heir appearance cannot pass by succession to his heirs, nor can it pass by the accused of an heir. Going to Syria now, we have not considered Syria now. Example is Sumil Muhammad had two sons, B and C. D died a lifetime of age, leaving a son D. A then died, leaving C his son, and D his grandson. The whole of A property will pass to C, to the entire children of D. It is not appear D to contend that he is entitled to this. I is representing that example. Second, in the case cited of their loss of the previous concept, it is well known principle of Mohammed that any of the children of a son died before the opening of the section of his estate, leaving children behind. His grandchildren are entirely excluded from the inheritance by their uncles and their the son of a priest's son is therefore not an heir.
just tell us one thing. In case of one daughter also, it is 2/3. Where will that 1/3 go? If it will not go to the residuaries and it will not go to, there are 3 classes of yours, right? There are 3 classes. One is sharers, which are first degree. Second is residuaries, right? This also forms in the first degree only. Third is distant kindreds. Are all those relation by blood who are neither sharers nor residuaries. So this person who is son of a deceased person whose father died during the lifetime of his grandfather, will he not fall under distant kindred? Why not?
Because there is a document, if you compare with DY1, thereby Muhammad Khan, the instructor has sold to entire land to his daughter. That is up in the year 1967 itself. Then the daughter has sold the property to this person in the year 1970. When the
I don't get it. Where is that finding that the property was sold by the grandfather to anybody?
Yes,
Where is that finding? Finding दिखाइए finding. ऐसे document से नहीं चलेगा ना?
the document is there.
That is not the substantial question of law. Anything which is not the substantial question of law, we will not touch.
But
The point is, you just cannot say, under normal circumstances, the remaining will go either to residuaries. You say that they are not class 1 or whatever, but certainly they would fall under distant kindreds.
thing in that means aunt and their heirs. Not
Sorry?
the deceased son of the deceased son.
Are all those relations by blood? They are relations by blood? Yes or no?
That is that's why
They are. Who are neither sharers nor residuaries. Who are neither sharers nor, ये तो बिल्कुल residuary का भी residuary है.
but they had documents say when he had two things. We have to section 52 and 53. Then Rashid Bhai put
52
further
and 52, 53 देखे और 61 नहीं देखे.
61 we have also come. We have also seen 61 also.
Yes.
But
You
once
just
it
say.
it has been held. And the son of Christianity, son is therefore not an heir. Once it has been held.
Where, in which judgment it has been held? Judgment दिखाइए ना.
I mean that has been quoted.
हाँ तो हम क्या करें? उसी से कोटेशन उठा लें. आपको जजमेंट लेके आना चाहिए ना. ऐसे नहीं होता.
They are able to listen to my views.
You are not in a position to argue.
No, that why we have
थोड़ा तो शर्म करिए.
to us.
2 घंटा से आपको सुन रहे हैं and you are not in a position to argue. सवाल पूछते हैं तो कुछ आर्ग्यूमेंट नहीं. साइटेशन दिया हुआ है तो दिखता नहीं है क्या?
Citation.
तो क्यों नहीं लेके आए?
But there is citation that Christianity son is not intact.
किस आर्टिकल में दिखाए थे आप?
Residuary.
नहीं ये जो आप नहीं किस आर्टिकल में? हाँ? AIR 1933. इसका बनाइए तो किताब प्रिंट निकालिए इसमें. AIR 1933 OUDH 142. Sorry. 142. You see, if this daughter had a brother, अगर भाई बहन होते तो रेसिड्यूरी भाई के पास चला जाता, पूरा का पूरा 1/3 उसको मिल जाता, बाकी पूरा का पूरा भाई के पास चला जाता. Right? But in a case where she does not have a brother, then it will go to the other branches. ये जो आप जजमेंट देख रहे हैं ना, इसमें अंकल एंड आंट दोनों भी होंगे. अंकल होंगे तो इसके पास आने का कोई सवाल ही नहीं होगा. लेकिन अगर अंकल नहीं है, ओनली आंट्स है, उसमें भी 3 आंट्स होंगी तो सबको 1/3 चला जाएगा, कहानी खत्म हो जाएगा. 2 आंट्स होंगी तो 2/3 चला जाएगा, 1/3 बच जाएगा. 1 आंट होगी तो 2/3 बच जाएगा, 1/3 आंट के पास चला जाएगा. लेकिन जो 2/3 बचेगा तो सरकार के पास नहीं जाएगा, वो उसी फैमिली में ये वाले जो क्या बोलते हैं डिस्टेंट किंडर्ड है, उनके पास चला जाएगा.
थोड़ा सा और I may be able to clarify the situation of residuary. I have given the reference of 65, section 65. इसी में classification of residuary has been given.
Yes.
I may be allowed to take it.
Yes.
All residuaries are related to the deceased through a male. The uterine brother and sisters are related to the deceased through a female, that is the mother. And
ये
they,
रेसिड्यूरीज तो पेज 65 में,
Article
if there are no sharers,
section 65 में further classification has been given or notings has been done, and it is at my page 78. Heading with classification of residuary.
78.
ये मेरे वाले में है 78.
Classification 82
Yes.
में.
Classification of residuary. इसी में right hand side में मिल जाएगा residuary that are preliminary, primarily share and female residuary.
classification of residuaries. All residuaries are related to the deceased through a male. The uterine brother and sisters are related to the deceased through a female, that is the mother, and they do not therefore find a place in the list of residuaries. The Siragia divides residuaries into 3 classes. Residuaries in their own right. These are all males comprised in the list of residuaries. 2 residuaries in the right of another. These are the 4 female residuaries, namely the daughter as a residuary in the right of the son, the son's daughter HLS as a residuary in the right of the son's son, the full sister in the right of full brother, and the consanguine sister in the right of the consanguine brother. 3 residuaries with others, namely the full sister and consanguine sisters, when they inherit as residuaries with daughters and sons' daughters. But if regard is to be had to the order of succession, residuaries may be divided into 4 classes. The first class comprising the descendants of the deceased, the second class his ascendants, the third class of the descendants of the deceased father, and the fourth are the descendants of the deceased true grandfather. This classification has been adopted in the table of residuaries. The division of distant kindred into the 4 classes proceeds upon the same basis.
Now let delete female residuary.
Female residuaries.
But female residuary, your case is not a case of
नहीं,
female.
not a case. Just for a case, we take minute I am referring.
सर आप ना केस से मत
नहीं, ठीक है.
things which are not relevant उसको नहीं. You see, you come to this.
सबसे डिफिकल्ट चैप्टर हम लोग स्टडी करते थे तो यही था, इनहेरिटेंस ऑफ मॉडर्न.
You see, you come to this. Next page. Female residuaries के बाद principles of succession amongst sharers and residuaries. इसको पढ़िए. whoever is related to deceased through any person shall not inherit while the person is living. है ना? Specifically dealt with.
Yes.
Whoever is related to the deceased through any person shall not inherit while that person is living. Thus, the father excludes brothers and sisters, and since uterine brothers and sisters are related to the deceased through mother, it must follow that they should be excluded by the mother. A reference, however, to the table of shares will show that these relations are not excluded by the mother. The reason is that the mother, when she stands alone, is not entitled to the whole inheritance in one and the same capacity as the father would be if he stood alone, but partly as a sharer and partly by return. Thus, if the father be the sole surviving heir, he will succeed to the whole inheritance as residual. But if the mother be the sole heir, she will take 1/3 as a sharer and the remaining 2/3 by return. For this reason, the mother does not exclude the uterine brother and sister from inheriting with her.
Return unit has also been defined
What is return?
in section 66.
If there is a residue left after satisfying the claims of sharers,
Just a moment. Yes.
if there is a residue left after satisfying the claims of the sharers, but there is no residuary, the residue reverts to the sharers in proportion to their shares. The right of reverter is technically called return or wrap. Exception: neither the husband nor the wife is entitled to return so long as there is any other heir, whether he be sharer or a distant kinsman. But if there be no other heir, the residue will go to the husband or the wife, as the case may be, by return.
इस return का क्या मतलब हुआ? If there is a
Not-
residue left, like in this case, 1/3 के बाद 2/3 बच गए.
अगर रेसिड्यूरी एग्जॉस्ट नहीं होता है, then it will return to certain person. Namely, this property.
If there is a residue left after satisfying claims of sharers, but there is no residuary, the residue reverts to the sharers in proportion of their share.
जैसे दो भाई बचे ऊपर,
दो भाई
अगर रेसिड्यू
सिंगल बेटी है, उसका क्या होगा?
एक बेटी है तो उसका होगा रेसिड्यू सिविल
कहाँ उसको उसका रिमेनिंग प्रॉपर्टी किसके पास जाएगा? Then by return she will get it.
By
He will get it by return.
By return, it will go to his brother or father or other kinder man. एक बार इसको लैंग्वेज को फिर से समझ गया, ये रिटर्न हो जाता था जब कोई उसका रेसिड्यू वाला नहीं मिला, तब रिटर्न हो जाएगा किस पर. If there is no
To the sharers.
But yeah, if there
is
is
technically called a return.
If there is a residue left after satisfying the claim of the sharers, but there is no residuary, the residue diverts to the sharers in proportion to the share.
the residue will go to in proportion to the sharers.
If there is no
If there is
residuary,
no one to share,
if
it
there
will
is
go
no
to the
residuary,
same person only.
तो यहाँ
So the entire will go to the daughter.
यहाँ
तो residuary है.
यहाँ तो रेसिड्यूरी है.
नहीं, ये जो रेसिडुअरी है, इनका कहना है कि इसलिए वो रेसिडुअरी नहीं है, because he is a son of predeceased, because his father has expired during the lifetime of his grandfather.
Therefore, I had submitted earlier that this is not the partition with respect to the property of those heirs.
No, this property stood as joint property so far as the all the four brothers are concerned. That is the finding.
This is the related suit between purchasers from two possessors. Vaida purchased the property
वो
from
तो हो गया, उसकी बात छोड़ दीजिए, बस आप इसके 2/3 की बात करें, बाकी तो only 2/3 की बात करें.
two
1/3 डॉटर के पास जाने के बाद 2/3 किसके पास जाएगा? By return she will get it.
Just clarifying it.
हम वेट कर रहे हैं उसी के लिए.
अदर रेसिडुअरी देखा जाए उसी के नीचे जो भी continuing sisters and daughters and sons.
मुझे फोकस नहीं हट रहा. एक ही चीज को हम इतना मान नहीं है, उसी के लिए हम वेट कर रहे हैं. हम सोच रहे हैं अभी आता होगा. अब हमसे दोबारा साइटेशन मांग रहे हैं. ये अब्दुल बारी वर्सेस नसीर अहमद. AIR 1933 और OUH 142. इसी से क्लियर हो जाएगा, इसी जजमेंट से क्लियर हो जाएगा.
I may be allowed to refer as separate from here, where other residuary.
कहाँ?
हमारे बुक में पेज 77 है. रेसिडुअरी के सेक्शन 65 के ही इंटरप्रिटेशन.
रेसिड्यूरीज का दिया हुआ है. उसके
नहीं,
बाद
हेडिंग है उसका आता है.
heading है. अदर रेसिड्यूरीज बोलते तो
ये देखा लेना. आइटम नंबर 4 में मार्क किया हुआ है करना.
क्लासिफिकेशन ऑफ रेसिड्यूरीज
उसके पहले
उसके पहले.
राइट हैंड साइड में नीचे
अदर रेसिड्यूरीज.
और उसमें थर्ड फोर्थ में मार्क किया होगा पेन का हल्का.
हाँ ठीक है. फुल सिस्टर, सिस्टर, ब्रदर, मदर, ब्रदर, सन, विडो, मदर, paternal uncle, son.
एक को अगर एक नहीं होगी तो इट विल गो टू सेकंड. सेकंड नहीं होगा तो इट विल गो टू थर्ड. दिस इज द वे ऑफ इनहेरिटेंस. ब्रदर सन इज आल्सो वन ऑफ द
ये तो अंकल सन हुआ ना. ब्रदर सन तो नहीं हुआ.
ये अंकल है ना.
अंकल सन.
यासीन की 3 बहनें थी.
हाँ.
इन 3 बहनों का रेसिडुअरी गया उनकी तीनों बेटियों पर. यासीन की तीनों बेटियों पर. दे आर ब्रदर्स सन और डॉटर.
तो रिमेनिंग कितना है इसका? 2/3. Remaining is how much?
Yes.
2/3. 2/3 into 1/4.
मोहम्मदीन खान का 1/4 शेयर है.
1/6 हो गया ना.
1/4 शेयर का
1/6 बचेगा ना.
1/6 will go to the plaintiff.
To the
According
plaintiff.
to the residuary schedule.
Yes. Brother's son.
Yasin was Yasin was one son, and there were 4 daughters of Yasin, 4 sisters of Yasin. Their share will go to brother's son, or son's daughter, or brother's daughter. कितना हुआ था इसका रेस्टिट्यूशन? 112 आ रहा था.
इसका रेसिडुअरी 112 आ रहा है.
After satisfying both the claims of the sisters, that is 2/3, we are left with 1/12 of 1/4.
Then I am not disputing that proposition. It is with respect to a will.
No, it is with respect to inheritance also. Because maybe that there was a will to a particular property. Will से तो will के हिसाब से जाएगा या जितना will permissible है मोमेंट लॉ में उतना ही जाएगा. वो अपनी जगह है. But a son who dies during the lifetime of his father is excluded from being a heir.
Yes.
Right?
Yes.
There is no dispute on that.
No.
Whether he would fall under any of the residuaries or he would fall under any of the क्या है?
Distant kinder.
Distant kinder.
Distant kinder.
or the property will go by way of return to the daughter.
Distant kinder अगर नहीं होगा, then it will return to
हाँ.
his brother and other heirs. Now can we have a look to the pedigree? मोहम्मदीन खान, इनका सन थे क्या नाम है, यासीन खान, और इनके और भी ब्रदर थे, वो डिपेंडेंट अलीमुद्दीन, मुजाबीन, मुकर्रबीन, मुसम्दीन, और ये यासीन खान की पत्नी हो गई जैबुन्निसा, अब बेटियां हो गई 3. तो दे आर डिस्टेंट किंडर ऑफ बीबी जैबुन्निसा एंड बीबी मुकर्रबीन. इनके तो डिस्टेंट किंडर में आ ही जाएंगे. यासीन खान को कुछ नहीं मिलेगा, शेयर नहीं मिलेगा, एडमिटेडली शेयर.
यासीन खान का शेयर से नहीं डिवॉल्व करेगा,
शेयर
ये
से-
डिस्टेंट किंडर के शेयर
किंडर के
से
शेयर से डिवॉल्व करेगा. Therefore, being the residuary, they are entitled to share of
they will
BB.
be under residuary or they will be under distant kinder.
Yes,
दोनों में से किस में आएंगे?
residuary में आएंगे, because they
वो
are
अदर रेसिड्यूरीज में
they are
ब्रदर्स सन, ब्रदर्स
brother's daughter.
ब्रदर सन लिखा हुआ है।
Son लिखा हुआ है, daughter
son
नहीं
लिखा हुआ है.
तो सन ही है ना ये, ब्रदर्स सन के पास जाए, उसमें नहीं लिखा हुआ प्री डिसीज पोस्ट डिसीज, ऐसा कुछ नहीं लिखा.
Residuary तो जो बच गए, कोई
As a residuary it will go directly to him.
उसमें भी क्लासिफिकेशन है. Who will get residuary property first? अगर पहले के नहीं है तब it will go to distant kinder. इनके कोई नहीं है, because यासीन खान did not inherit the property of his father, but उनकी बेटियां inherit की थी अपने फादर का प्रॉपर्टी मोहम्मदीन खान का. Who are dependent number 12, 11, 12, क्या है? 7, dependent 8, 7, 8.
Brother's son as residuary, it will go 1/6. Let me just have
यहाँ इनहेरिटेंस की बात नहीं है, यहाँ है रेसिड्यूरी का. Who will be entitled to
they
रेसिड्यूरी?
will not get through their father,
Yeah,
there is no doubt on that, but they will get as residuary
as residue. And
because
claim-
maximum 1/3 would go to the his father's sister.
plaintiff number 2 का claim भी on the basis of residuary है, whereas plaintiff number 1 का claim है on the basis of purchase of Waliuddin's property.
That's right.
That's all.
रुक जाइए एक सेकंड, just hold on. इस चार्ट में लिखते हैं. ऐसे इसको देखते हैं। मोहम्मद खान, चारों बच्चों को 1/4 मिला, राइट? उसके बाद ये जो 1/4 मोहम्मदुद्दीन खान को जो मिला, यासीन खान had died prior to that, तो इसीलिए यासीन खान के बच्चों को यहाँ से कभी कुछ नहीं मिला।
नहीं
उसके बाद जो 2 और भाई हैं, they died issueless,
अली
काम
मुद्दीन
खत्म हो गया।
मुजाहिदीन
उसके बाद जो बीपी डिफेंडेंट नंबर 7 जो है
जी
और डिफेंडेंट नंबर 8 को,
बीवी मुकद्दम
दोनों को 1/3, दोनों को 1/12 शेयर मिला, दोनों को 1/12 शेयर हुआ।
ऑफ द प्रॉपर्टी ऑफ मोहम्मदीन खान।
हाँ, ऑफ द प्रॉपर्टी ऑफ मोहम्मदीन खान, दोनों को 1/12 हो गया, करेक्ट? यस, यू टेल अस।
नहीं 2/3 दोनों बहन लोग को मिला,
1/4
नहीं ऐसे ऐसे नहीं, आप ऐसे बीच में मत चले जाइएगा भाई, प्लीज डोंट डू दिस। अपने अपने लिए भी 2-4 जूनियर रख लीजिए, कोई दिक्कत नहीं है, लेकिन इस तरह से नहीं चलिए।
नहीं ठीक है, पूछा जाए
ये सबको 1/4 मिल गया, ठीक है? उसके बाद मोहम्मद खान, यासीन खान पहले मर गए, तो मोहम्मद खान के पास जो 1/4 प्रॉपर्टी था विल नॉट गो टू यासीन खान एंड हिज ब्रांचेस डायरेक्टली, इट विल गो टू अलुमुद्दीन मुजबिन, ये दोनों मर गए पहले ही। अब बचे डिपेंडेंट नंबर 7 एंड डिपेंडेंट नंबर 8, राइट? तो डिपेंडेंट नंबर 7 के पास मैक्सिमम 1/3 जाएगा ना इनका, तो 1/12 हो गया, 1/3 इंटू 1/4, ये 1/12 हो गया। इनके पास डिपेंडेंट नंबर 7 के पास भी 1/12 हो गया, तो इन लोगों का हो गया 2/12 विच इज इक्वल टू 1/6, इनके पास चला गया, राइट? अब 1/6 के बाद कितना बचा? 1/6 के बाद 1/4 माइनस 1/6, करेक्ट? 1/12 बचा। Now this 1/12 will go to the plaintiff number 2, correct?
तीनों चारों प्लेंटिव हो जाएगा।
हाँ, लेकिन रिलिंक्विशमेंट है ना,
दे हैव रिलिंक्विश
1/12 जाएगा प्लेंटिफ नंबर 2 के पास, क्योंकि प्लेंटिफ नंबर 3 हैज रिलिंक्विश्ड एंड प्लेंटिफ नंबर 1 हैज आल्सो रिलिंक्विश्ड, एंड प्लेंटिफ नंबर 4 किधर है?
वही यासीन खान के भाई का।
ये हाँ, ये दे हैव ऑल रिलिंक्विश्ड, P4, P3, P1 in favor of
P2
P2, तो P2 के पास 1/12 चला जाएगा, और जहाँ तक P1 है, she gets the entire property of Waziruddin Khan,
वजीर मोहम्मद वजीरुद्दीन खान
by way of
by
purchase,
way of
यही है।
यही
and this he comes under the category of other residuaries, and 1/6 he is otherwise also entitled, ठीक है? बताइए। डॉक्यूमेंट का अब इसमें कोई हम कुछ नहीं कर सकते डॉक्यूमेंट, क्योंकि वैसा कोई क्वेश्चन ऑफ लॉ नहीं है।
So now what is the share of the plaintiff? If Yasin Khan died, if I calculated the share,
He will get no share of, he will get no share of Muhammad Khan directly.
now come to the finding again, or the court has come to the finding. So which action of share plaintiff will get? Now come to the finding of trial court. It has been discussed.
डिस्कस नहीं, सीधे फाइंडिंग में आइए, डिस्कशन हम लोग बहुत देर से कर
So
रहे हैं।
they come to the finding. Or some part has been left.
ट्रायल कोर्ट का कौन सा फाइंडिंग है? एपिलेट कोर्ट का फाइंडिंग देखिए ना, ट्रायल कोर्ट ने तो कोई शेयर ही नहीं डिसाइड किया।
Trial court has decided the appellate court has not decided. The appellate court by the this effect.
Appellate court only said that this property is subject to partition.
No, it has said it is extended the matter of some say. Kindly come to the finding. Right, I am concerned.
Which finding do you want to read?
From paragraph 25. Discussing all the things. Why the court has come to the in support of partition is created by the conjecturing the following argument for it. Paragraph 25. Mohammed
You
Khan.
just see, you para 11 पढ़ी है ना? Para 11. पेज नंबर इंटरनल पेज 3 इनका यही केस था 112.
Paragraph 11. One post here, Muhammad Khan had a living son. Yasin that he died during the life of his father, leaving on his wife, Jabunisa, a son, Salahuddin, and two daughters. Khalid. Now this is the pleading. Now I come to
This is the pleading only.
What is the finding of this?
Yes. Where is the finding?
Yes, I come to the finding. But there is difference.
Para number.
Paragraph 32. In this I would like to mention here that there are 12 defendants in this. Copy defendant number 1 to 9 are the heir of 4 above liars.
ये सब नहीं पढ़ी हम लोग सब पढ़ चुके हैं आप सीधे फाइंडिंग में आए You just come to the
Paragraph 35.
paragraph. ये तो पार्टीशन की कहानी है इसमें क्या है Nothing. इसमें शेयर का क्या कहानी है कुछ नहीं है इसमें finding.
Muhammad Khan, who is one of the posts, had sold his share in care of her daughter Musharin Bibi through credit number such and such 24666. Revival. Then the grandfather has sold the share.
This property was sold.
That was sold in 1967.
This property
This property
was sold to whom?
to whom he sold to his daughters. Then daughter has sold the property to this person. Then the question is come. What the share remain to the other residue or other persons?
When did this person die? Who has sold? आप हमको genealogy से बताइए कौन कौन किसको बेचे? Show me from the genealogy. Who sold to whom?
Muhammad Khan.
बताइए.
Muhammad Khan.
Mohammad Khan.
Muhammad Khan, from which the Nasim Khan other has claimed.
Yes.
Who sold the property to his daughter Bibi Musali.
यहाँ पे डॉटर का कोई कहानी नहीं है. नहीं ये तो 4 बेटों का कहानी है. इस genealogy में कहाँ है daughter?
वो अली मोहम्मद खान. अली मोहम्मद खान had 4 sons.
अच्छा तो
Daddy
अब
मोहम्मद शरीफ खान,
ये मोहम्मद खान की
मोहम्मद
बात, आपके ना वॉइस क्लियर नहीं है प्लीज. आप ये मोहम्मद खान की बात कर रहे हैं, बेटा की बात कर रहे हैं.
हम मोहम्मद खान की बात कर रहे
अच्छा इन्होंने किसको बेचा?
हैं. अपनी बेटी को.
कौन सी बेटी को बेचा?
ये बीबी मुस्लिम को बेचा.
पूरा प्रॉपर्टी.
Yes. वही आया.
कौन सा सेल डीड है बताइए? कहाँ है ये फाइंडिंग?
B/1.
एग्जिबिट
B/1. Then suit plot.
sold the entire suit property.
entire suit plot. Then para B.
entire suit property कैसे बेच देंगे? वो उसका तो 1/4 शेयर ही है.
1/4 से नहीं बेचा.
suit property to बताइए.
Suit property to Muslim. बीबी Muslim.
defendant number 8.
And then she has sold the property
to whom?
to whom that has come to the purchasers. In the year
And you are representing you are the defendant purchaser.
I am dependent person. And we say in a partition of 3588 have been passed before sunset.
exhibit B/1.
Yes.
exhibit B/1.
One of 20.
दिखाइए जरा B/1 का डिस्कशन दिखाइए कहाँ? exhibit B/1 का डिस्कशन दिखाइए.
अपरेट जजमेंट के पारा 11 के मिडिल में देखा जाएगा. एग्जिबिट B/1 is a sale deed number 7470 dated 24/9/1987 executed by Muhammadin Khan in favor of Mursalin Bibi regarding plot of Khata number 5 and 7 and others, but the suit plot has not been mentioned in this sale deed.
कहाँ पे बताएं?
हम पढ़ रहे हैं पेज 11 का अपरेट जजमेंट मिडिल में.
मिल गया? हो गया? नहीं है ना इसमें इंक्लूडेड?
है. यहाँ बोल रहे हैं कि टोटल इसमें जो आया है मुझे पूरा पार्सल है टेकन प्लेस. ये क्या है? कलामुद्दीन खान के डिफेंडेंट दे फाइल WS that a person has taken place of their entire land including suit.
कहाँ पढ़े?
नेक्स्ट पारा पेज 11 का पारा B.
पेज 11 का पैरा
35 पारा B.
35 कहाँ है?
पारा 35 पेज 11. चार कुछ
एपिलेट कोर्ट से पढ़िए ना. एपिलेट कोर्ट से पढ़िए.
बट वे कम चार को 10 पे कम तो which share I have they call WS that a person had taken place of their entire land through the suit plot and the entire variety of co-recorded against they are divided by mission by giving these among courses.
पैरा 35
35B. First they find 1A in G. WS also exhibit
ये तो WS का बात कर रहे हैं ना.
उसमें
तो डीड में तो नहीं है ना ऐसा.
एडमिट किए हैं कि पार्सल हो चुका सारा प्लॉट था.
तो डीड से दिखाइए ना कि ये प्रॉपर्टी इंक्लूडेड है. हम लोग इधर उधर क्यों देखते हैं? शो मी फ्रॉम द डीड दैट दिस प्रॉपर्टी इज इंक्लूडेड. एग्जिबिट B/1 निकालिए और डीड से दिखाइए.
I have first completed. What are the share I have?
नो यू शो मी फ्रॉम द डीड. इतना कंफ्यूजन का क्या बात है? डीड है यहाँ पे. शो मी फ्रॉम द डीड दिस प्रॉपर्टी वाज इंक्लूडेड.
Is the data mistake on the part of the writer? Can't come to the
मिस्टेक ऑफ द राइटर इन द डीड. बहुत अच्छी बात.
No, not in the deed. Not in the
Yes, sir.
plate itself. In the plate itself, that which come the year 1984. In the plate of 1935-84, what they have written
But there was a
In the
mistake
schedule.
in the plane.
Yes, written in the plate, they have mentioned the plot number instead of 544, they have mentioned 424. Area is same, 1.30, 1 acre 30. Now he said it is only should go in the previous one. It has not been partition.
ऐसा कोई यहाँ पे क्वेश्चन ऑफ लॉ नहीं बना.
But he is admission, even different number 1.
अच्छा आप सुनिए.
Then
ऑर्डर
also
सुनिए.
admitted.
अच्छा ऑर्डर सुनिए. देखिए. essay number 315 of 2016. For the learned counsels appearing on behalf of the parties, this appeal has been filed against judgment dated 31st of March 2016 within bracket decree signed on 11th April 2016 passed by learned District Judge Roman 7 Palamu at Daltonganj in partition appeal number 5 of 2009, which has been dismissed with modification of the judgment and decree dated 12/12/2008 within bracket decree sealed and signed on 6/1/2009 passed by learned Sub-Judge Roman 2 Palamu at Daltonganj in partition suit number 64 of 2002. The appeal was admitted for final hearing by order dated 29/11/2018 on the following substantial question of law. Whether the plaintiffs are entitled for partition, although father of plaintiffs, namely Muhammad Yasin Khan, died in the lifetime of Muhammadin Khan. The learned counsel appearing on behalf of the appellants has submitted that it was an admitted fact in para number 7 of the plaint that Muhammad Yasin had died during the lifetime of his father Muhammadin Khan. He has referred to article कौन सा आर्टिकल आप रेफर किए थे 53? Article 52 and 53 of chapter 6 dealing with inheritance, that's general rules in as mentioned in the book, namely namely Principles of Mohammedan Law by Mulla, 22nd edition, and has submitted that right of a heir apparent or presumptive comes into existence for the first time on the death of ancestor, and he is not entitled until then to any interest in the property to which he would succeed as an heir if he survived the ancestor, and has submitted that in case the son is deceased, then his then the grandchildren are entirely excluded from inheritance. the learned counsel submits that since Yasin Khan had predeceased his father Mohammedan Khan, his wife and other children were not entitled to any share in the property, which otherwise devolved upon the two surviving sisters of Yasin Khan. The learned counsel has submitted that in aforesaid circumstances, allocation of any share to wife and children of Yasin Khan is not justified in law. The learned counsel has submitted that the learned courts have not taken into consideration this aspect of the matter, and in view of the fact that Yasin Khan had died prior to his father Mohammedan Khan, the impute judgments allocating any share is not sustainable in the eyes of law. He has also submitted that the property which belonged to Ali Muhammad Khan, who is the original recorded tenant, the suit property involved in the present case was sold to the defendant number 8, wide exhibit B by 1. And therefore, during his lifetime, Ali Muhammad Khan had sold the entire property to defendant number 8, wide exhibit B by 1. But this aspect of the matter has also not been properly considered by the court. If the property was sold to defendant number 8, then under such circumstances, the appellant who are the purchasers from defendant number 8, you are the purchasers from defendant number 8. The appellants who are the purchasers from defendant number 8 acquired right title and interest over the suit property. B by 1 दिखाइए. सूट प्रॉपर्टी का डिस्क्रिप्शन बताइए.
Property खाता number 7, plot number 524, area 1.30.
खाता नंबर 7, प्लॉट नंबर
524.
B1, right? इसका तो वेंडर है इसका तो वेंडर है कमरुज़्ज़मा खान. वेंडर तो अली मोहम्मद खान है ही नहीं इसमें.
मोहम्मद खान, not अली मोहम्मद.
नहीं अली मोहम्मद खान नहीं है.
मोहम्मद खान.
नहीं, एग्जिबिट B by 1 का वेंडर वो नहीं है.
Kamru Jama is exhibit B by 2, who is the son of the Iltaf Khan, one of the son of the Ali Muhammad.
नहीं आपका डीड तो एकदम नहीं मैच करता जो बोल रहे हैं वो आप बिना डीडी पढ़ के बोल रहे हैं सूट प्रॉपर्टी के क्या डिस्क्रिप्शन है खाता नंबर 7 प्लॉट नंबर
Plot number 524.
इसमें 415 इट इज नॉट मैचिंग कुछ भी बोल कहाँ से बोल रहे हैं ना तो ऐसा कोई ऐसा नहीं ठीक है हम देख लेंगे प्लीज डोंट डिस्टर्ब लाइक दिस
See there, 5.
आपके एग्जिबिट B by 1 बोले ना
B by 2 is also there. 130 is there. B by 2 can't carry. It is not required.
प्लीज वी डू नॉट
If it is not there, then I cannot see. 524
नहीं
is
ऐसे
1
नहीं कर सकते ना जिसका सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बना आई एम नॉट सपोज्ड टू आंसर दैट आई एम नॉट सपोज्ड टू आंसर एनीथिंग which does not form a part of substantial question
This
of
is one part has a very
law.
should
अब आप बैठ जाइए
very should not who purchase the same
ठीक
and from whom. Muslim Bibi had purchased the same from one Kamru Jama who was the original owner.
अच्छा ठीक है आपको सुन लिए ना बहुत सुबह 10:30 बजे से सुन 10:30 बजे से आपको सुन रहे हैं ना बस हो
But I can show like this.
कोई बात नहीं अब थोड़ा सा दूसरा कोर्ट के लिए भी छोड़ दीजिए अपना एनर्जी The learned counsel, so far as Muslim law is concerned, आपको इतना ही बोलना है. The learned counsel appearing on behalf of the respondents has submitted that the property that it is not in dispute that Yasin Khan had predeceased his father Muhammadin Khan, but the 1/12 share of the property would have devolved upon the brother's son by virtue of the fact that brother's son comes under the category of other residuaries. We have submitted that at the time of death of Mohammuddin Khan, there were only 2 surviving daughters who would have inherited to the extent of 1/3 of the share of Mohammuddin Khan. Since Mohammuddin Khan acquired 1/4 of the suit property, therefore their share came to 1/12 each and total came to 1/6. And the remaining portion of the property that is 1/12. 1/12 will be remaining. 1/12 would go to the brother's son, that is son of Yasin Khan, and by such property would go to brother's son, irrespective of the fact that Yasin Khan had died, had predeceased his father Muhammad Ali Khan. Okay? The Learned Council has referred to Article 61, which deals with the classes of heir, which reads as follows. And then he has referred to the list of other residuaries given in the same book, which as per sequence, which includes brother's son. The Learned Council has submitted that had there been any surviving brother of Yasin Khan, then the property would not have gone to the brother's son. But since Yasin Khan did not have a surviving brother, and after allocation of share to his two sisters by way of residuary, the property devolved upon the brother's son to the extent of 1/12 of the share. Okay? The Learned Council has also submitted that so far as substantial question of law is concerned, the children of Yasin Khan were entitled for partition as a portion of the share had devolved upon them in view of the aforesaid provision of Mohammedan law. And the fact that Yasin Khan had expired prior to his father Mohammedan Khan is not in dispute, and his death prior or after will have no impact so far as the right of other residuaries are concerned. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the common ancestor was Ali Muhammad Khan, who had 4 sons. And with respect to the other properties, apart from the suit property, there was a previous partition. So far as the dispute so far as 3 branches, namely the branch of Sarfir Khan, Sharif Khan, Muhammad Altaf and Muhammad Waziruddin Khan are concerned, there is not much dispute, except that the plaintiff number 1, granddaughter of Mohammedan Khan, had purchased the property, the entire property which was allocated to Muhammad Waziruddin Khan from his legal heirs and successors, and such transfer has been held to be valid by the learned First Appellate Court. And no substantial question of law has been framed in connection with the transfer of property from the legal heir of Waziruddin Khan to plaintiff number 1, correct? The entire dispute is in connection with the branch of Mohammedan law, Mohammedan Khan. Mohammedan Khan had 5 children, including Yasin Khan, who died during lifetime of Mohammedan Khan. His 2 sons died issueless, and at the time of his death, he was survived by his 2 daughters, who were defendant number 7 and 8. Yasin Khan at the time of death, left behind his wife, who was plaintiff number 4, and his 3 children, plaintiff number 1, 2, and 3, respectively. It is not in dispute that plaintiff number 1, 3, and 4 had relinquished their share in favor of plaintiff number 2, so far as inheritance from Mohammedan Khan is concerned. The bone of contention is as to whether upon death of Yasin Khan during the lifetime of Mohammedan Khan, any property could at all devolve upon the 4 plaintiffs who were wife and children of Yasin Khan. This court finds that there is no doubt that upon death of son, his legal heirs and success, upon death of son during the lifetime of the father under Mohammedan law, their children do not succeed the property directly through their father. However, in the present case, defendant number 7 and defendant number 8, being the 2 surviving daughters, were entitled to the extent of 1/3 share each to 1/4 share which came in the hands of Mohammedan Khan with respect to the suit property, and consequently they got 1/12 of the entire suit property, total coming to 1/6 of the entire suit property. So far as the remaining property is concerned, since they did not have any surviving brother, the property was to devolve through the other residuaries as mentioned in the aforesaid book and quoted above, and brother's son falls under a residuary, and as per that, the residuary is entitled to 1/6 share. 1/6 of whatever was devolved. One-sixth as residuary. इसका क्या मतलब हुआ? 1/6 का क्या मतलब हुआ सर?
1/6 हुआ that is the share which may be allotted to your son. जैसे
The son's
the
son, son's son,
son-
brother's son.
brother's son.
हाँ.
So they are in the factual circumstances.
So
of
the
this-
entire will go to them. Remaining. ये बुक आपका मेरे पास है क्या?
हाँ,
हाँ दीजिए तो।
वही
हाँ, ये।
पर्टिकुलर किस के संदर्भ में प्रश्न किया गया
नहीं
है?
इसलिए हम जानना चाह रहे हैं कि जैसे कि 1/12 तो 1/6 तो आ गया दोनों डॉटर्स को, सो एंटायर रिमेनिंग विल गो टू देम.
Yes, remaining will go to residuary.
ये जो 1/6 इसमें लिखा हुआ ये नहीं समझ आया, 1/6 क्यों लिखा?
1/6 या daughters को, 1/6 या daughters को brother's son as residuary.
अच्छा, और तो कोई है नहीं.
नहीं, brother's son के अलावा और तो residuary में कोई नहीं बचा है.
और तो रेसिड्यूरी में कोई नहीं
नहीं,
बचा.
कोई नहीं बचा है.
ये डिवीजन ऑफ द अदर रेसिड्यूरीज के
Yes.
बीच में
Yes,
फुल सिस्टर ये सब रहते तो.
yes.
हाँ?
वो उसके ऊपर देखा जाएगा कंसीविंग सिस्टर एंड डॉटर्स एंड सन्स डॉटर्स उस नोट में भी दिया हुआ, फिर अदर रेसिड्यूरी का लिस्ट दिया हुआ. रेस्ट विल गो टू ब्रदर्स सन एज रेसिड्यूरी which has been left by division number 7 and 8. And the entire
ये
property,
फुल सिस्टर क्यों लिखा हुआ है हाफ शेयर? फुल सिस्टर टॉप में हाफ शेयर.
full system half share. Well, I may be allowed to clarify this.
Yes, please clarify.
If half share is divided, is given to full sister, and there are two sisters, they will get 1/4 each. तब the sisters में division होगा.
फुल सिस्टर को तो 1/3 ऐसे ही मिलेगा.
1/3 मिलेगा. 1/3 मिल गया उसको, दोनों को एक 1/3
1/3 मिल जाए, रिमेनिंग का हाफ हाफ.
रिमेनिंग चला जाएगा रेसिड्यूरी पर, ब्रदर्स सन पर, और उसमें 4 हैं. रेसिड्यूरी में 4 हिस्सेदार हैं. 3 हिस्सेदार एक के फेवर में अपना रिलिक्विश कर दिए, राइट? तो प्लेंटिफ नंबर 2 इज सीकिंग रिलीफ ऑन द बेसिस ऑफ रेसिड्यूरी, and the plaintiff number 1 is seeking relief on the basis of having purchased the property 1/4 of Wajuddin Khan.
ये सब सन है तीनों, इनके तीनों बेटे हैं यासीन खान के,
यासीन खान के बेटा केवल सलाउद्दीन है,
और बाकी दोनों
बाकी दोनों बेटियां वहीदन और शाहिना, और उनकी बेगम थी जैनुन्निसा.
तो इन लोगों को रिलिक्विशमेंट भी तो करने का कोई जरूरत नहीं.
नहीं, relinquishment of being some son, he entire get rest of the residuary.
This court is of the considered view that after satisfaction of the share of the sharers, that is the 2 daughters of Mohammuddin Khan, the remaining would go to the residuaries, and consequently it would go to the brother's son,
Brother son,
namely plaintiff number 2, right?
only
Who
brother
has been
son.
allocated share to the extent of 1/12, and thus the entire 1/4 share of Mohammuddin Khan with respect to the suit property stands divided between two sisters and one stands divided with respect to defendant number 7, defendant number 8 and plaintiff number 2 to the extent of 112, 112 and 112. Okay?
Yeah.
This court finds that the learned first appellate court has divided the share, has allocated the share to plaintiff number 2 to the extent of 112, and therefore
इसमें एक
the
वोट अगर जो
impugned judgment does not fall for any
एक वोट जो एड रजिस्ट्रेट हो रही
as restituted.
एड
As restituted. चलिए. The substantial question of law is accordingly answered. मेरे ख्याल से इतना में ही हो जाना चाहिए, बाकी इतना तो लिखने का कोई जरूरत नहीं. Rest of the story. Dismissed. Call करिए अभी. मोहम्मद लॉ का कुछ से केस सुन रहे
ये
हैं.
बहुत इंटरेस्टिंग है अगर आपको मन लग जाएगा तो
हम लोग के पास कोई ऑप्शन थोड़ी रहता है. मन जो काम करना है उसमें मन लगाना है.
वो तो अलग बात है लेकिन
और हमको सब काम में मन लगता है.
यंग एज में हम लोग बहुत भागते थे. मेरा गुरु भी मोहम्मद था, उसी से हम सीखे थोड़ा बहुत. और अभी तो हमारे दो राइट हैंड है.
नहीं आपका ये
They are
जूनियर
trying-
लोग अच्छे से तैयार हो गए हैं.
they are trying to get the
नहीं नहीं पढ़ने से
mastery in
समझ-
modern law.
चलिए ठीक.
अपने
जबकि यही एक ऐसा फील्ड है जो जल्दी से लोग छूते नहीं हैं.
छूते
मतलब एडवोकेट्स जल्दी से इसको थोड़ा सा कंफ्यूजन रहता है. एज अ लॉ स्टूडेंट आल्सो थोड़ा कंफ्यूजन रहता है. चलिए करने से सारे काम हो
Item
जाएंगे.
item 3 MA 252 of 2023.
Yes, please. What is this?
This is an assigned matter.
Assigned matter.
Yes. Assigned, not assigned, actually the bench was between initial and then
Assigned
it was assigned.
तो क्या करना है इसमें?
This is a matter in which this appellant interpreting
अच्छा अच्छा. अब क्या करना है बोलिए.
your ratios.
अब बहस करिए. अब क्या बचा है? रेलवे क्लेम्स. You are the claimant. Where is the respondent? Counsel for the respondent was there in the morning. सोचे होंगे टेकअप हो जाएगा.
Also prepared.
आगे. Are you ready?
Yes.
चल.
Also prepared a statement.
बताइए.
This appellant, he was traveling.
Claim has been rejected.
Claim has been rejected.
On what ground?
On the ground that he was, the ticket was not found on his premises, the ticket was not found. And secondly, the tribunal held that he has not been able to prove that the accident occurred as a result of an untoward incident. The railway claims says that
Accident had occurred.
accident has
He died on the
not
spot.
died. He has been injured.
Injured.
He has his he has an injury. He has thighs. The left thigh has been amputated. The entire left thigh has been amputated.
Bona fide.
The left thigh has been amputated. From the left thigh has been amputated.
What is untoward incident?
Untoward incident means
Which is railway claims.
123C2 explains the untoward incident and it says that
Untoward incident. Correct. Railway claims act. What
any
is it?
person who has a fall from a running train, any passenger who has a fall from the running train is would be there are three definitions. 123 would be the untoward incident means accidental fall of a passenger from a running train.
From the train. If a person is on the track and if he meets the accident, then it will not fall under
That will not
untoward.
count. It has to be an accidental
So you have to
fall
prove, no, that you have fallen.
Yes.
What is the witness?
The witness is the person who was there at the time of who has
Did he have the ticket?
He did not have the ticket.
Oh.
Not have the ticket. नहीं. He he lost the ticket.
Lost
There's a
the ticket.
difference between not having a
Who
ticket
will
and
prove?
losing the ticket.
Who will prove? How did he prove that he ever had the ticket?
He has filed affidavits to that.
Affidavits?
Devi
Affidavits से ticket
case,
कैसे replace
Hina
होता?
Devi, there is a citation I will give it to
Did you?
petition.
Citation did you?
Citation. Wherein it says what is how will the person previously there was lot of
You see,
decisions.
जिसका एक्सीडेंट हुआ उसका भी टिकट गुम हो गया.
उसी का ticket.
नहीं, जो विटनेस है वो कैसे बोल रहे?
Witness तो वो देखा था फॉल करते हुए. वो he was there at the place.
होता है. He was at the place of
Places
occurrence.
occurrence. He is Rohit Mishra. He was the person who lodged the sanha कि ऐसा आदमी इस ट्रेन के जाने के बाद हम लोगों को मिला. इसको ट्रीटमेंट के लिए हम लोग
जाने के बाद मिला कि गिरते हुए देखे?
गिरते हुए मतलब he says
कहाँ है उसका एविडेंस बताइए? He is PW?
He has not been examined. He has lost the sanha.
Why he has
Patient
not been
has to
examined?
understand that these are incidents. He's a
देखिए यहाँ
independent
पे ना
person.
mercy तो नहीं चलता
He
है.
is an independent.
Mercy beyond law is
He is
not
an independent
a part
person.
of this
He is an
court.
independent person. He is
His
not
son-
somebody related to this. This the court could have called for him. If he has lost the sanha as an independent person, कि इसको ये देखा गया.
कहाँ है?
The court-
सना पढ़िए तो. रोहित मिश्रा पढ़िए. इंक्वायरी रिपोर्ट में उनका है ना स्टेटमेंट. पढ़िए.
Page 5. Page 5 of the LCR unit. And also next
Page 5 is the inquiry report.
page 5 उसका इसमें
आप कौन सा डॉक्यूमेंट पढ़ाना चाहते हैं बताइए? Which document?
ERM report is at page 9.
Page
ERM
9.
report is a statutory inquiry conducted by the railways in this regard, and in that they said that हम लोग that an inquiry was. First, let me give a brief of this case.
हम समझ गए आपका story.
हाँ, this person was.
आप हमको बस एविडेंस दिखाइए.
हाँ, evidence.
उन्होंने बोला है ऐसा भी बताइए कि ट्रेन से गिरते हुए देखे. बस इतना
Yes,
दिखा
sir.
दीजिए, हम आपका केस अलाउ करें.
That is annexure 4 to my appeal only. That I
Annexure
annex the diary.
आप किसकी बात कर रहे हैं? जो मेरे पास रिकॉर्ड से आया है उसी की बात करेंगे ना.
Records में जो उसका मेरे पास वो ये नहीं है.
जो चीज आपके रिकॉर्ड में नहीं है ना वो हम नहीं देखेंगे.
LCR में है.
वो हम देखना चाहिए.
LCR में है. रोहित मिश्रा पेज.
ओके, वी हियर यू ऑन मंडे. अभी तो हम लोग को उठना होगा. वी हैव रेफरेंस. अभी रेफरेंस है ना.
हाँ.
वी हैव टू राइज. नहीं तो सुन लेते हैं. लिखिए. अपने अपीयरेंस देंगे दोनों जने. MA number 252 of 2023. The learned counsel for the appellant has commenced the argument and has submitted that the learned tribunal has wrongly decided that no untoward incident as defined under section 123 within bracket C1 within bracket 2 of the Railway Act 1989 happened with respect to the victim. She has submitted that the independent person who had lodged sanha and his statement was also recorded at the stage of inquiry has fully supported the case, but in spite of that the findings has been recorded against them. यही आपका. Since the court time is over, post this case for further hearing on Monday 10:30 first case कर लेंगे.
Because there are few contempt applications,
As
but it
we-
remain on the board itself.
What
Next
everything
Friday.
will remain on the board.
Next Friday. Yes, we'll take.
एक आया था क्या आप लोग का क्या हुआ?
That has not been
नहीं,
yet
Mr.
done.
अशोक यादव से.
Eli was there because I am
क्या
also
हुआ?
preparing in the same contempt.
क्या हुआ? कुछ नहीं हुआ.
No cabinet decision as yet.
उसमें कैबिनेट 2 बार बैठा है, लेकिन इस आइटम का शायद नंबर नहीं आया या ये डिसीजन नहीं.
अच्छा हुआ आज आपके केस का नंबर नहीं आया. 1:30 बजे के बाद हम एडवर्स ऑर्डर्स नहीं करते.
I prepared a written notes for him.
देखिए. 1:30 बजे के बाद ना कोई DFT ना कोई एडवर्स ऑर्डर एज अ मैटर ऑफ प्रिंसिपल 1:30 बजे के बाद और 4:30 बजे के बाद एवरीबडी इज फ्री टू लीव द कोर्ट आफ्टर 1:30 एंड आफ्टर 4:30 ऐसा मेरा मानना है इसके लिए कोई एडवर्स ऑर्डर नहीं हो सकता